Yes,
My lord, subsequent to my mentioning on 13th of this month, the record has come to this court, but it is not being listed.
No, regarding what?
MSCC hearing.
Hearing matter.
The paper books are ready and exchanged.
Yes, give it.
my lord, this is for application in MSCC.
MSCC application.
Stay application, yes, madam.
Yes.
Lordship, upon notice, I'm mentioning one.
Just a minute, please maintain your seniority.
Stay application in connection motor accident claim appeal.
Yes.
Another application in connection with motor accident appeal.
Yes, yes, please. Yes.
One application upon notice, Your Lordship, connected with a second appeal.
Application in connection with second appeal.
Second appeal
Yes.
for inclusion. I'm grateful, Your Lordship.
Your Lordship, for inclusion in the list.
With regard to
FMA 1020 of 2.
claim case.
Yes.
Yes.
My lord,
Yes.
this is the final hearing stage, my lord. Two claim cases here, motor accident claim case.
Hearing case.
Yes, my lord.
Yes.
Lordship, MSCC hearing matter, my lord, for inclusion in the list.
Yes.
My lord, hearing MSCC claim case, my lord.
Yes, please.
Ready, my lord. Ready for
My lord, আমার একটা মামলা আছে FMA 5592
আপনার হয়ে কি কোনো উকিল বাবু দাঁড়াচ্ছেন?
মাই লর্ড, তাহলে আমি উকিল বাবুকে অ্যাপয়েন্ট করব। মানে আমার একটু মেডিকেল ইমার্জেন্সি আছে, তাই মামলাটা
আপনার মামলা আছে, ওটাতে কোনো উকিল বাবু নিয়োগ করেননি?
না।
Yes, let it appear as to be mentioned.
Number 2.
I'm appearing on behalf of the applicant, my lord. This is the affidavit of service.
No, this is your application, can
Yes,
for.
Yes, my lord, can for. Initially, my lord, order was passed by the learned trial court challenging the same. Insurance company preferred the appeal. Appeal was disposed of with liberty was given to the appellant to realize the claim amount from the owner of the offending vehicle, and liberty was given to the present applicant to withdraw the compensation amount already deposited.
Yes.
But my lord, the spelling of the applicant has not properly been mentioned in the
What was there in the original claim case? Those names are there in the appeal.
Yes, my lord. I have annexed the Aadhaar card and other identity proof, my lord. In paragraph 6, my lord, I specifically mentioned. In my lord, some places in place of I, it has been written you. As my lord, applicant number 1, Bosiran BB.
Yes, respondent 1, applicant number 1.
Yes, my lord. Instead of RAN, it should be RUN.
The name of the husband of this
Same.
respondent is not correct. The name of the husband.
Name of the applicant.
Name of the applicant is recorded as Basirun Bibi.
Basiran BB, whereas it should be RUN. Next, my lord.
Okay, instead of this Basiran Bibi, it should be Basirun Bibi.
Yes, my lord. Next, my lord, applicant number 3, Noor Nabi. This is together pronounced NOORNABI. Instead of NUR Noor, separately Nabi. Well, specifically, all the changes has been mentioned in paragraph 6. And my lord, during pendency of the appeal, my lord, 6 and 7, they become major. So the kindly allow this application and necessary application.
Yes, let it be allowed. Yes, record an order. Learned advocate for the respondent's applicant is present. The application for correction of the spelling of the names of respondent number 1, 2, 3, 4.
1, 3, 4, 5.
So 2 we have also mentioned in paragraph 6.
Yes, my lord, specifically mentioned in paragraph 6. All the
Paragraph
changes.
6, whatever you have mentioned.
Yes, whatever I have mentioned.
Yes, for correction of the names of the respondent number 1, 2, 3, 4, 5, 6, and 7. Stop. In paragraph 6, the applicants have contended that the names of the respondents, which is recorded in the wrong spelling be rectified and corrected. The particulars of the rectification to be made is mentioned in paragraph 6 of the application. It is further contended by the applicants that respondent number 6 and 7 have attained majority during the pendency of the appeal. Stop. Thus, this application stands allowed. Let the names of respondent number 1, 2, 3, 4, 5, 6, and 7 be rectified and corrected as mentioned in paragraph 6 of this application, and the names of respondent number 6 and respondent number 7 be recorded as major. Other contents of the award remains unaltered. This application stands disposed. The department to make necessary correction within 2 weeks.
And my lord, they are permitted to withdraw the compensation amount.
Yes, upon correction to be caused by the department, the applicants, claimants may withdraw the amount which is deposited.
Grateful, my lord.
Sir, this appeal has come at my instance. Yesterday I mentioned, my lord, on 26/11/2025, your lordship was pleased to hear out both the my lord learned advocates and my lord the paper book I filed.
26/11.
26/11 is the date for judgment.
26/11.
Kindly see the order.
Right. Now I remember. Yes, record an order. Learned advocates for the
সব দিয়ে hearing হয়ে গেছে।
appellant, learned advocate for the appellant is present. As the hearing of this case is already concluded, let it appear for judgment on 2/12/2025.
Yes. পেপার বুক দেওয়া আছে, তো পেপার বুক দিয়েই দেওয়া আছে।
Four I am there. Now this is a stay application. We have deposited the statutory deposit. Let there be stay till further order.
Yes, record an order. Record টা দিন একটু।
Now here is the copy of challan.
So this matter was hard or what earlier? এটা কোনটা দিচ্ছেন? 5 নম্বরটা দিচ্ছেন।
Item number 4, my lord. 4A.
Yes, give the challan. এই ইয়েটা দিন, ওটার মধ্যে ঢুকিয়েছি। Yes, learned advocate for the appellant is present. As the appellant has deposited the statutory amount of ₹25,000, there shall be an interim order of stay of judgment and order dated 18th November 2020, passed by the learned additional district judge, first track, second court, Diamond Harbour, South 24 Parganas, in MACC case number 61 of 2019 for a period of 5 weeks. The appellant shall take steps to deposit the awarded sum along with interest from the date of filing of the claim case till date of deposit within the period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the interim order of stay shall continue till disposal of this application. Liberty to mention. The Registrar General is requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time.
Item 5.
Item 5 with 6, my lord, I am for the respondent insurance company.
My
There is
lord,
some
your lordship,
correction.
kindly see the order dated.
Order, or no, what rectification is to be made?
Rectification is, my lord, what happened, my lord? My lord, the owner of the offending vehicle, my lord, the
No,
applicant,
what are you seeking in this matter? You are the appellant.
I'm for the appellate.
Yes.
My client has come for the enhancement of the award passed by the tribunal.
Anyway, this matter was heard on the last occasion.
Last occasion, and your
The
lordship,
part hard.
your lordship was pleased to fix the matter as specially fixed matter. Paper book.
Huh?
My lord, kindly remember, my lord, one family.
ITI, the
Yes.
student of ITI, my lord, remember?
Yes.
My lord, your lordship, kindly
No,
see
this is
the-
correction of any order.
My lord, correction is,
Okay. The matter was directed to appear today as a specially fixed matter.
as specially fixed matter.
Yes.
Let it be fixed on Monday at 12, my lord.
Lord, your
It'll be better.
Yes, record an order. The matter is put up for necessary rectification. In the cause title, instead of FMAT within bracket NV, it shall be FMAT within bracket MV. Let the necessary rectification be made in order dated 21/11/2025. Let this matter appear
As
at
specially
12 p.m. on 1/12/2025.
that is, my lord, one
Monday.
Monday. At 12, I'm getting.
Monday.
What is it?
7, my lord. I am for the respondent insurance company, my lord. Kindly allow
দুটো
a short
matter
passover.
analogous কিন্তু।
Short passover.
Okay, pass over.
My lord, I am for the appeal in this case. It's a railway untoward incident case. In this case, already I filed my written argument, and other side has submitted the written argument to me today, Your Honor.
So it is ready for hearing.
It was ready for hearing on the other bench, and written argument was already filed, my lord.
Anyway, I have to hear out the
Yes,
matter.
I am ready
I am
So come tomorrow, I am keeping it tomorrow.
tomorrow.
Yes, let this matter appear on 28/11/2025.
Now, can it be fixed on Monday, because they are saying that the council will not be there?
Inner council is suffering from influenza.
2/12/2025.
1/12 to
2/12.
2/12.
For the respondent. Paper book has already been filed, my lord.
You are for the appellant.
My lord, I am for the appellant, my lord. The paper book for the my lord, my learned friend, my lord, has prepared the paper book, my lord. It has
You
already
are
been
for
filed.
the opposite party, respondent. So paper book is ready.
Yes, my lord, I have already filed. Lord, my lord will fix up a date for hearing.
Yes, record an order.
Right, so.
Learned advocates for the parties are present. It is submitted by the learned advocates that the paper books have been filed and the matter is ready for hearing. as it is a motor accident claim case and the matter may be settled, the matter is referred to National Lok Adalat in the
But
held
this
in
cannot
the
be settled. This
month
cannot
of
be
December. Anyway, then fix
Uh,
8/1
but this cannot be
2026.
settled.
I'm keeping it in the month of January, but prior to that, I'm sending to Lok Adalat. If it is not settled, I'll hear it
But
out
this
on.
cannot be settled. There is a wild allegation against my client.
Very
This
well,
cannot
very
be
well.
settled.
Try to settle.
And this cannot be settled.
Mr. Singh will take
No,
instructions.
he cannot.
8/1 2026 for report of the National Lok Adalat.
No, it is settled, sir.
10, my lord, I am for the petitioner. In a proceeding under section 138 of Negotiable Instrument Act, I am the accused petitioner. My lord, challenging the rejection of my prayer under section 311 of CRPC for my lord recalling of complainant PW1 for recording further evidence that was rejected, turned down. My lord, challenging the said order, I preferred this revisional application. My lord, during pendency of the revisional application, since there was no interim order, so my lord, the learned magistrate was pleased to issue warrant of arrest against me. My lord, when the matter was moved, the motion was moved before my lord Justice Subra Ghosh, her ladyship was pleased to my lord grant me liberty to appear before the learned jurisdictional magistrate, and limited stay was granted with regard to the warrant of arrest. So for merit of the matter, my lord was pleased to direct me to serve a notice. Now my learned friend is appearing.
Question is, the matter is due to appear under the heading contested application.
Well, now the urgency, what happened? Well, since
Your Lordship can dispose of the matter.
yes.
He has
Well,
challenged the order dated 6th of June. But there was
what
no
has happened?
stay.
Kindly,
The application become infractuous because already at the stage of argument.
well, kindly see the last
So,
order, 3rd
the
of
order-
November.
Let me see, which is the order under challenge?
6th of June 2024.
No, let me see the order under challenge. 6th of June 2024.
Yes.
The certified copy, last page.
Yes.
This order has been challenged. That's it.
So this order is under challenge, 6/6/2024.
There was no stay, there was no interim order. Only
Oh, this order, this is an order of rejection.
Yes.
Against that you have come.
That was challenged in the present divisional application.
Yes.
Now, during pendency of the divisional application,
There was no stay of the
there
proceeding.
was no interim
So
order.
it continued.
So, my
The
lord,
application has been infractuous.
on 6th of September 2024, my lord, subsequently, warrant of arrest was issued against me. Since I did not participate in the proceeding, I wrote a letter, advocate's letter. The matter is pending before this
No,
court.
6/6/2024.
Thereafter,
Your petition was rejected 10/6/2024.
yes.
It's fixed for arguments.
Thereafter, I challenged that order in this present
During
divisional-
pendency of this application.
Yes.
The warrant of arrest was issued
Subsequently.
as because there is no order of
No,
stay.
I did not participate in the proceeding. I have challenged that order. That order was
So 24/9/2024, what is this order?
kindly see my order dated. My lord,
No, you see, you
Because
have challenged that.
Present application now infractuous.
No, you have challenged this order
Yes.
dated
6th of June 2024.
Okay, you have challenged this order
my
here.
lord.
So thereafter, at the time of admission, what order is passed?
No.
Kindly see order dated 24th September
Yes,
2024.
24th
Well, kindly have a look to that.
That is only warrant of arrest. That relates to. এখন অর্ডারটা দিয়ে তুমি তো বুঝতে এখন কেন করেছিস এটা দিয়ে
So without prejudice to your rights of the main case, okay,
Warrant was.
So this order is passed. That
No, I am
matter is kept pending.
Well,
Application is
at the
application is
present,
pending,
Matter is
but
kept
there
pending.
there was no stay. The proceeding is
at
going
the
on.
present, I
He
am
was given an opportunity to surrender with the on or before 4th October.
I surrendered,
2024.
got bail. Now
That you got.
that part is closed. So
Okay.
now what I have mentioned, kindly have a look to the order dated 3rd November. This is the
As there was no stay, proceeding is continuing. It
continuing.
is now at the stage of
Kindly
argument.
have a look to the order dated 3rd November 2025. Then I will make my submission. Only for this reason I have mentioned this matter.
Now, so far I understand, against the warrant of has been issued.
Now again,
That's
warrant
why
of arrest has been
valid
issued against the present petitioner.
Your lordship can dispose of the application. Well, nothing.
The matter is to appear as contested application.
No,
It is both parties to be heard.
I am not
What I'm
pressing.
telling you,
He is my other side. I am not pressing about the main divisional application. Again, warrant of arrest has been issued. Kindly stay the warrant for a limited period, and the next part that
So
are
you want this matter to be disposed.
disposed of. Well, kindly have a look. Then my order dated 3rd November 20. Then I will make my submission.
If there is no stay of the order.
Today is fixed for argument positively in default judgment. Complainant is present by Hajira, accused is absent by time petition. Both sides heard, advocates are present, both sides learned advocates are present. Heard, both sides, time petition, OP, and so is rejected. Issue warrant of arrest against the accused, fixed 6th of January 2026 for execution of warrant of arrest. Well, I am praying stay of this order. Again, I will go and surrender. Only the remaining part is the argument. Well, kindly permit me to participate in the argument proceeding, and then the London magistrate will deliver the
Dispose
charge.
of the.
Only this much prayer I am making.
It's a case of 2019.
Kindly stay this
Already 6 years.
warrant for
apart.
limited period. I shall go and take regular bail, and kindly direct the London magistrate. Allow me to make my written notes, to submit my written
So how
notes
much time do you require to go
within
and
10 days. Well,
First 6th of January is date fixed, next date fixed. Kindly see. 6th of
meanwhile,
January.
that warrant may be stayed. Only for this purpose I have mentioned.
yes, record an order.
Lord, may I submit? Stay for 2 weeks. In the meantime, he will appear and that application will be disposed of.
The only
So far the
difficulty
merits
this
is
accused
concerned,
person has
it will
been
be hard
engaged
in
by the
accordance with
BLO. So after 4th he will be free. He has been appointed as BLO for SR job.
So when you will be free?
After 4th it is set to
December, 4th December.
Yes. Learned advocate for the
Bargain
parties that
proposal.
present.
2 weeks later.
Hard learned advocate. This instant revisional application is directed against order dated 6/6/2024 by which the learned judicial magistrate, 3rd Court Tamluk, Purbo Medinipur,
Opposite party.
was pleased to reject the prayer of the petitioner under section 311 CRPC and fix the case for arguments. Stop. As the petitioner failed to appear before the learned trial court, a warrant of arrest is issued against the petitioner in the meantime. Learned advocates for the petitioner submits that he is not willing to proceed with the main application, but an opportunity be granted to surrender before the learned trial court and obtain bail and participate in the proceedings. Stop. Upon hearing the learned advocates and upon considering the facts of the case, this court is of the view that in the interest of justice.
Advocates for the complainant also, madam. I am
Learned advocates. Shall I record your consent?
No, madam.
I have just recorded
Yes,
hard
yes.
done. If you want, I can record your consent.
No, deeply applies, madam.
Upon hearing the learned advocates and considering the facts of the case, this court is of the view that in the interest of justice, the petitioner should be granted an opportunity to appear before the learned trial court and participate in the proceedings. Thus, the petitioner is granted opportunity to appear before the learned trial court on or before 12/12/2025. Stop. In the event the petitioner appears before the learned trial court within this period, the earlier order issuing the warrant of arrest will stand recalled and the petitioner will be permitted to continue on the earlier bail.
Well, the last warrant was issued from 3rd of November. That should be mentioned, my lord.
The warrant of arrest issued against the petitioner on 3/11/2025 will stand recalled and the petitioner should be permitted to continue on the earlier bail. However, in the event the petitioner fails to appear on or before 12/12/2025, the learned trial court will be entitled to proceed in accordance with law. The warrant issued on 3/11/2025 shall remain stayed till 12/12/2025.
Grateful.
This application stands disposed.
Well, that certified copy of the order may be kept in the record, my lord.
The certified copy of the order sheet dated 3/11/2025 be kept with the record.
But the revisional application is
Stand
Yes,
disposed.
disposed.
Developed.
Well, I'm for the appellant, my lord.
Yes. Whose application is this? Can 2?
Cantu was a deed for exhibition of the deed before the court executed in favor of the son of the first wife
Or additional evidence.
as additional evidence.
Can 3?
Can 3 was my lord, paper book has been completed, my lord. Everything is
Paper books are ready.
already completed.
Anyway, let it appear for hearing.
My lord.
Yes, record an order. Learned advocates for the parties are present. It is
I am
submitted.
1 and 2. I am for respondent number 1 and
Learned advocate for the appellant and learned advocate for respondent number 1 and 2.
For the railway authority.
1 and 2, and you are for respondent number?
Railway authority. 3 and 4.
And learned advocate for respondent number 3 and 4 are present. As the paper books have been filed and the appeal is ready for hearing, let this appeal appear for hearing on, yes, after 2 weeks.
My lord.
in the month of January, my lord.
Yes, yes.
In the
Appear
month, well, it should be long.
appear for hearing on 6/1/2026.
My lord. Grateful, my lord. My lord.
Grateful.
Or 12, brother.
Yes.
Well, this is an application under Section 5 of the Limitation Act. Your lordship.
So service is complete.
Service complete.
Has the respondent entered appearance?
And
Any lawyer is representing the respondents?
my lord.
If somebody, it is appearing as to be mentioned. If somebody is being represented, then you serve him.
Right. নামটা আছে এটা?
No, other side, respondent.
Other side.
Respondent কে appear করছে to. You have filed the track report that it
Yes,
is
yes.
duly served.
Yes.
It's better I keep it tomorrow under the heading application because it is appearing as to be mentioned. Yes, learned advocates for the appellant is present. Let this matter appear on 28. No, লিখে দি 28/11/2025 under the heading application.
Kindly take it tomorrow.
13?
13.
Yes.
I am appear for the
Tomorrow, I am for the respondent railways, my lord. Tomorrow I am in a bit of difficulty.
my lord, in Monday. Monday,
Not
Tuesday.
this week.
Not this week.
Grateful, my lord.
Not this week. Monday.
It's a very small matter. Paper book complete. Paper book is still not completed.
My lord, Monday it will be come. It will.
Can you do the needful by Monday?
Grateful, my lord.
14, my lord, I am appearing in this matter, my lord. Today I am filing the supplementary paper book, my lord. The copy is illegible because, my lord, the certified copy itself has been handed over to us, this type of copy. My lord, let him examine the LCR, my lord.
My lord, there was an order on the last occasion by which there was a direction for me to take inspection of the record. It was prayed by me. Now, what happened is possibly the records did not go down to the department. I could not take an inspection in spite of me filing the inspection slip. So, my lord, a specific direction be given so that the records go down to the department so that I can have an inspection.
You take instructions from your client, whether your client is ready and willing to settle. Because in the month of December, there will be a Lok Adalat. If it
My
is
lord,
settled,
I'll take, in the meanwhile, let me complete this exercise.
you cause inspection.
Yes.
Let the matter be sent to Lok Adalat.
Yes.
I'm keeping it in the month of January. Yes, record and order.
One thing more, my lord. My lord will not kindly take this on record. The supplementary paper book of his, why I tell you, my lord, is that because this paper book consists of only one document, which my learned senior friend said is illegible. Moreover, there is another document, and this supplementary paper book is bereft of that document, which is the Exhibit B, being the inquest. That is not a part of the paper.
Trial court's records have come.
Yes, TCR is there.
Yes, learned advocates for the parties are present. Learned advocates are granted opportunity to take inspection of the trial court records and thereafter prepare supplementary paper.
My lords.
As this is the motor accident claim case, the matter is sent to Lok Adalat for the purpose of settlement to be held in the month of December. Let this matter appear on 7/1/2026.
Well, there's a record be good down to the department. Otherwise,
let it go to this thing, Lok Adalat first.
Then I'll not be able to take the inspection possibly. If it doesn't
Okay.
go down to the department.
Let the records go to the department for the purpose of inspection.
I'm grateful. Well, may I have this liberty to also for apply a certified copy, because I will be requiring the copy. Mere inspection won't.
And certified copies may be applied for.
I'm good. I'm good.
And you take instructions. Okay?
Yes, I'm good.
Lordship 16, I am for the petitioner, Lordship.
My lord, I beg to appear on behalf of the opposite party and instruction to oppose this application. My lord.
No, is it with regard to NI Act?
Yes, Lordship, and the matter
What is this application? Is it admitted? This
No, Lordship, it's at motion stage. Not
motion stage, was there any direction to serve copy?
No,
and
no,
then
no.
Lordship,
Copy
I
has
have
not been
served
served.
it.
No, any admission
My
stage.
lord,
She is not bound to serve copy.
My lord, I'm not praying for the copy, my lord. What he has, my lord, he has communicated the pendency of this application before the trial court. For the
Yes.
trial court, we came to know.
Yes.
Here, my lord, friend, my lord, question is that he has asked for handwriting expert. That was, my lord.
That is, you see, whether this application will be admitted or not.
But
that
my
is
lord,
the
kindly
question.
see this High Court order that has been suppressed. My lord, kindly see.
No, in connection with this
This
case.
this is the matter is posted for argument. High Court directed to, my lord, conclude the trial within 2 months. Then, my lord, this question is only to, my lord, kindly
The
see.
question is it for why? No. This order is passed in this petition.
Yes, in this connection with this case.
How can it be passed? It's earlier a petition.
In case of in connection with this case.
Lordship, this revisional application is
see,
1051 of
Court
20.
may direct to dispose of expeditiously, okay? But in the meantime, some interlocutory application is made and that is rejected, okay? So here's that gives rise to a fresh cause of action.
Yes, but my lord, kindly see in the order passed by this High Court, what was the stage at that time? Stage was for the argument. In a stage of argument, my lord.
Well, you see, if the petitioner is unable to
Well,
justify, case will be dismissed.
Let him.
So when is the next date before the trial court?
1st December. 1st December 2020.
1st December 2020.
2025.
1st December. So anyway, I'm granting you opportunity to take adjournment there. You move before the regular bench.
Lordship.
Yes, record an order.
And my lord, to direct my learned friend to serve a copy upon
To
the
see that I cannot direct. After hearing, when the matter is admitted, then only that service can be effected.
Otherwise, my lord, what will happen,
You
my
see,
lord?
see, that is the procedure. In criminal matters, after the matter is admitted, copies are directed to be served. Because if it is dismissed, no
That
question
is
of service of
that
copy.
is true. But my lord, when is my lord is protected, my learned
No, other
friend
thing I can do one thing, okay. If both of you, this is under which Zenai Act, if you want to settle, I can send it to Lok Adalat also.
No, there's no issue of settlement, my lord. Because of that, my lord, this is the verge of the pronouncement of judgment now.
Very well, at any stage, even at the appellate stage also you can settle. There is
Then-
no bar.
Then we have to take
Lordship, for
take the instruction.
I am agreed.
Then I have to take the instruction. Or my lord, send it. My lord, we will, my lord.
Yes, learned advocates for the petitioner and learned advocate for the opposite party. Both the opposite parties.
Yes,
Opposite parties are present.
No, my lord, perhaps we are the only
Lordship, opposite
two.
party. One and
Yes, opposite parties.
How, my lord,
husband
can
and
be
wife.
two, my lord. The complainant is only one.
Representing whom?
Husband.
My lord, the complainant.
No, who is the complainant?
Yes,
Opposite party number 1 is the
Okay.
complaint. Opposite that.
Learned advocate for the petitioner and learned advocate for the opposite party number 1 complainant are present. This matter arises out of section 138 of the Negotiable Instruments Act. Stop. As the learned advocate for the opposite party number 1 has appeared, service of notice upon the opposite party number 1 is dispensed with. However, the service upon opposite party number 2 may be affected.
My lord, copy is required. My lord, I have
No, I'm directing. Let a copy of this application be served upon learned advocate for the opposite party number 1. Stop. As it is submitted by the learned advocates that there may be a chance of settlement, this court thinks it fit to refer the matter to be heard by the Lok Adalat.
Not my local, it will be mediation center. Mediation.
So
Lok
that
Adalat,
also I can direct.
that is the mediation center secretary.
The matter
member secretary
heard and considered by a mediator.
Member secretary,
Yes, that
High
is
Court.
there. So thus I refer this matter to mediation. Dash is appointed as the learned mediator. Learned mediator is requested to take steps to resolve the disputes between the parties amicably. Let the matter appear before the.
My lord, may I say, my lord,
Yes.
don't take me amiss, my lord,
Yes.
subject to lordship kind sanction. In case when, my lord, this court used to, my lord, to refer this matter before the mediator, there are the order, the matter has been sent to the, my lord, the member secretary of the mediator, and they will appointed any.
Both practices there. And that can also be done in some matters. Also, courts also appoint. If
Yes,
the court,
that's true. I'm not.
Yes,
And
yes.
my lord, the report is, my lord,
Yes, yes, definitely.
required to place before your lord.
Yes. Let the matter appear before the regular bench on 5/1/2000, or let it be some days more. 7/1.
10 or 15 any day. It will take time.
10/1/2000. 12/1/2026 for report of the learned mediator. Stop. As the matter is sub judice before the court and sent before the mediator, the petitioner may pray for adjournment before the learned trial court, which may be considered.
Grateful.
The department shall send a copy of this order to the to the Secretary Mediation Committee.
My lord, may I take back the order?
Yes.
Grateful.
My lord, 17 is insurance appeal.
The payment part.
My lord, pursuant to this honorable court's earlier direction, my lord, I have secured the entire compensation amount before my lord's court. Lord, today, lordship will kindly, my lord, make this stay absolute and will pass directions for filing of paper books, my lord. My learned friend would file that.
Deposited the entire amount.
Lordship.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the entire awarded sum along with interest in terms of order dated 10/7/2025, there shall be a stay of the judgment and award dated 5th day of March 2025, passed by the learned additional district judge, first track, first court Tomluk, Purmo Medinipur, in MSC case number 17 of 2022 till disposal of this appeal. Okay, the appellant shall take steps to cause service of notice upon the respondents through the department.
My learned friend is appearing on behalf of the claimants.
Okay, as the claimants, respondent number
1 to 3, Milord.
1, 2, and 3 have appeared. The service of notice upon respondent number 1, 2, and 3 is dispensed with. A copy of the memo of appeal and the application be served upon learned advocate for the respondents number 1, 2, and 3.
My lord.
Steps be taken to cause service upon respondent number 4 through the department.
My lord.
Have you filed your power?
My lord, we have prepared the paper book within 15 days.
Okay. The paper books may be filed on or before 9/1/2026. Okay, liberty to mention.
Grateful to your lordship. Blessed.
Okay. 80 million, I am for the petitioner, Millet.
Yes.
Millet, on last occasion, your lordship was pleased to direct me to take instructions about the next date. This is an expeditious trial I have prayed for in a 138 proceeding. Millet, the case is pending at the stage of the execution written of the warrant. Initially, it was at the stage of the cross-examination of the witness. At that stage, the accused did not appear, so the learned magistrate was pleased to issue warrant of arrest. Millet, the next date for execution written is fixed on 30th of March 2026. That is the date fixed, Millet, as I have seen from the e-court server, Millet. Millet, it's a proceeding of 2014.
Have the copy?
No, Millet, I have it.
Don't have the hard copy.
No, Millet, I have checked it from the. Millet, the case has been initiated in the year of 2014. The plea was recorded in 2018. The evidence in chief was done in 2019, and cross-examination is being continuing since then, and warrant has been ultimately issued in 2022. Thereafter, Millet, this is continuing since long. Sometimes the learned PO was on leave, sometimes the execution returns are not there. For last few dates, Millet, there is no execution written and the accused is not appearing. Consequently, Millet, this is continuing.
Yes, record an order. Learned advocates for the petitioner is present. Our learned advocate for the petitioner. As this application is directed for expeditious disposal of complaint case number C within stroke 9368/2014 pending before learned judicial magistrate 16th court Calcutta. This court is of the view that no fruit.
Millet, it will be learned 17th court, Millet. It will be learned 17th.
Your cost title.
Millet, I had made a mistake, Millet. It will be learned 17th court.
Earlier pending before, earlier or present?
Presently, Millet.
Presently before learned judicial magistrate 17th court Calcutta. This court is of the view that no fruitful purpose will be served by directing service of notice upon the opposite parties. Stop. Learned advocate for the petitioner submits that evidence of this case was complete in No, the examination in chief of the witness of the complainant were complete in the year 2019. Stop. Thereafter, during pendency of the cross-examination in the said year, the accused opposite party absconded. Until today, the warrant has not been executed. Learned advocate submits that unless there is a direction for expeditious disposal upon completion of the execution of the warrant, the petitioner will suffer irreparable loss and injury. In the facts and circumstances, this application is disposed with a request upon the learned Judicial Magistrate, 17th Court, Calcutta, to dispose complaint case number 6/9368/2014 expeditiously from the next date fixed. Stop. And take all necessary steps so that the earlier order regarding execution of the warrant is complied with. This application stands.
If your lordship kindly fix a date, that within 6 months, since the case is pending for last 11 years.
You dispose of the case very expeditiously, preferably within a period of 6 months from the next date fixed. Upon taking necessary steps for execution of the warrant.
Extremely.
Well, 19, well, I am for the petitioner. Well, the expeditious, well, this is expeditious disposal of the C case, well, 84 of 2019. Well, in this case, well, I am the complainant. Last 6 years, well, I am suffer.
What is the stage of the case?
Well, 313 has been done. They, the opposite party has appeared. Well, they prayer before the court that they submitted DW last 1 year. Well, kindly direct that.
You see the last order?
Well, last one, my lord. Well, the 3rd of May 2025.
So 6/9/2025 was the last date.
Yes. Are they not submitted DW?
No.
Again.
When is the next date fixed?
Well, next date.
January, if I'm.
No. I think the month of December, whatever.
Only thing is, lordship, I being the accused, I have filed an application. I've been told I have filed an application for.
This is with regard to NI Act.
Yes, madam.
As an accused, I filed an application that my witness be taken on commission because I am a patient having stammering problems and oath. That has been filed. Lordship passes an order and not stand in the way of.
Yes, record an order.
Please let that application be considered and that can happen. Lordship.
Advocates for the
time frame.
Parties, learned advocate for the petitioner, and learned advocate for the opposite party number.
Opposite party, my lord. The C case, my lord.
Opposite party.
Yes.
No. There are 2 opposite parties.
Yes, my lord. Opposite parties. Have you
You are
filed
for?
Lakshman Agarwal.
You are
One
for?
lordship. Lord Lakshman Agarwal. The accused.
Opposite party number 1 are present. Heard learned advocate. This application is directed for an order that the learned trial court the learned trial court shall take steps to dispose of the complaint case number 84 of 2019 under section 138/141 of the Negotiable Instruments Act, pending before the Court of Learned Judicial Magistrate, 6th Court at Howrah.
My lord.
Upon perusing the petition and upon hearing the learned advocates, this court is of the view that no fruitful purpose will be served by directing service of notice upon opposite party number 2, as the main opposite party number 1 is before this court. Stop. Thus, this revisional application is disposed with a request upon learned Judicial Magistrate 6th Court at Howrah to dispose of complaint case number 84 of 2019 very expeditiously and preferably, when is the next date?
The month of January, my lord.
Okay, and preferably within a period of 3 months from
I'm grateful.
from the next date fixed.
Yes, madam.
In the event any interlocutory applications are pending before the learned magistrate, the same should also be taken into consideration and disposed without granting unnecessary adjournment.
I'm grateful. Grateful. The next item are same, my lord, this same opposite party, my lord, case number 85.
Instead of 84 seat, it will be
85.
Let me see the record.
Man.
না এটাকে লোয়ার কোর্টে ফাইল করেছে ও আচ্ছা এই উইটনেস কমিশন সেটাই
আচ্ছা, ওই একই আছে, খালি ওই কমপ্লেন কেস নাম্বারটাকে একটু চেঞ্জ করে দেবেন। সেম ম্যাজিস্ট্রেট, কমপ্লেন কেস নাম্বারটা হলো কমপ্লেন কেস নাম্বার 85 of 2019। ওইটা বাদে বাদ বাকি সবই এক।
I'm grateful, madam.
I'm so grateful.
1920. I'm grateful.
Twenty. 21, my lord, I am for the petitioner. My lord, this revisional application, my lord, has been preferred before this honorable court, challenging the order dated, impugned order dated. Order dated, my lord, 24th of April 2025. My lord, your lordship kindly comes to the impugned order, my lord. Your lordship will find it after affidavit page, my lord. Certified copy has been given. After certified copy.
Yes. Yes, 24/4/2025.
Yes, my lord, 24/4/2025. My lord, your lordship kindly comes to the last paragraph, my lord. It appears that the check amount of rupees 1,42,50,000 and
No,
this
which
court
paragraph?
finds it
24/4/2025.
25. Yes, my lord, the last paragraph.
Last paragraph.
In this respect, it appears
Yes.
that the check amount of rupees 1,42,50,000 and this court finds it proper to grant interim compensation to the tune of 10% of the check amount, that is 14,25,000, and the accused is directed to pay within 60 days. My lord, your lordship kindly comes to the paragraph 10 of the complaint, 138 NI Act complaint, my lord, paragraph 10.
Yes.
My lord, your lordship sees that the check bearing number 003457 dated such and such. Here, my lord, the amount is 17,63,288, and as such, my lord, with the 138 application, my lord, from the 138 application, my lord, this order does not even tally. And my lord, your lordship kindly sees that the impugned order, though, my lord, it is suffering from irregularity, my lord, it has been passed by the learned judicial magistrate, my lord, at the verge of the commencement of the trial. To this effect, my lord, the petitioner says that he issued a check to the complainant, my lord, as a security check, not for its encashment. To this effect, this order has been passed by the learned judicial.
Are you challenging the quantum of the check amount?
No,
As per
I'm
this paragraph, you see, you are relying upon paragraph 10.
Paragraph
So
10. my
paragraph
lord,
10, the quantum is 17,63,288.
288.
What is your ground of challenge of this matter, this order?
My lord, the order, I'm challenging this order, my lord, since the order suffers from irregularity.
Yes,
My lord,
irregularities regarding what?
regarding the quantum of the interim compensation. And to this effect, my lord, I'm praying for stay over this impugned order, as because this order has been passed at the verge of the commencement of the trial, my lord. My lord, uh, uh, regarding the 138
Were
NI.
you given an opportunity to file your objection with regard to this
Yes,
interim?
my lord, yes, yes.
So you are given an opportunity of hearing.
My lord, under this circumstance, my lord, I'm praying for stay over this, my lord, impugned order. My lord, at
Was there
the
any
time,
prayer made, application made for payment of interim? Yes. One petition was made.
yes, my lord, by the complainant it was made, and to this effect, my lord, this order has been passed. My lord, this order has been made by the learned judicial magistrate, my lord, at the verge of the commencement of trial, my lord. My lord, during the pendency of the trial, my lord, it can be understood. But, my lord, at the verge of the commencement of trial, my lord, this order has been passed.
Okay, after how many days the trial commenced? When was this case instituted?
At 2020, my lord.
2020.
Yes, my lord.
So long time ago the case was instituted.
But, my lord, this order has been passed, my lord, at the verge of the commencement of trial. My lord, in this application, I'm praying for stay over
Show me
this.
the relevant provision of the NI Act regarding interim compensation. NI Act din to?
My lord, 143A. I do not have the book with me. I'm sorry.
अच्छा इधर है. Yes, I'm keeping it at 2 p.m.
Yes.
Come with that book.
My lord, I do have the section, my lord, regarding.
No, it's better you bring that book instead of mobile. I am also calling for the book. You come at 2 p.m.
Yes, my lord. My lord, 22, same matter, my lord.
Okay,
The-
both 21, 22 at 2
Yes,
p.m. 2 p.m. fix আছে কিছু? হ্যাঁ? তুই judgment নাকি কোনো matter আছে? Okay, it's better. আচ্ছা, এটা বই আনান তো negotiable instrument act. It's better you come at 1 p.m. Okay.
But I'm for the petitioner. Not proceeding under section 138 at the verge of cross-examination of the witness, I sought time that was turned down and cross-examination was closed. So I wanted only one opportunity so that I can cross-examine that particular witness. Page 14. Page 14, my lord. Order dated. Page 14 is your lordship. And that order was assailed subsequently to the learned sessions judge. That order was confirmed. First order, your lordship will be finding at page 14.
Yes, record an order. Learned advocate for the. So this order, page 14 is a 2022 case.
Yes, my lord, that was challenged in learned session judge. Subsequently, that was same order.
What is that order?
That order I have annexed. Your lordship will be finding certified copy.
Yes.
Last but second page, the ordering portion. Here in this case, learned trial court has rightly rejected the prayer, paragraph 22.
Yes, paragraph 22.
Considering this fact, not necessary to interfere into the impugn order. So ultimately.
Yes, record an order. Learned advocate for the petitioner is present. This application is directed against the order passed by learned judicial magistrate first class, learned judicial magistrate 5th Court, Howrah in 840C of 2015 and affirmed by the learned additional district judge, first track 3rd Court, Howrah in criminal revision number 11 of 2023. Stop. In the instant case, the question of law involved is whether the learned trial judge rightly passed the order in rejecting the prayer for adjournment when such adjournment was sought on the ground of illness of the accused person. Stop. Upon perusing the petition and the order passed by the learned trial court and the appellate court, this court is of the view that this application should be admitted. Thus, I admit this revisional application. Let notice of this application be served upon the opposite parties within 1 week. An affidavit of service be filed forthwith. Let this matter appear on 9/12/2025 before the regular bench. Pending hearing of this application, there shall be a stay of further proceedings further proceedings in connection with case number 840C of 2015 pending before learned judicial magistrate 5th Court, Howrah till 15/12/2025.
Deeply obliged. Deeply obliged.
Yes. Just a minute, Passover matters, yes, both sides present.
Yes, Lordship. Lordship, this matter already disposed of and Lordship's substitution application before Lordship money disbursement, before money disbursement, the injured persons expired. Then Lordship's his wife and also son and daughter filed these applications for substituting the same. পাচ্ছে না
এটা নিন এখন এটা নেবেন
Lordship, I have stated in paragraph 3. Country. Lordship, this is substitution application original.
Which respondent died? Oh, claimant.
Claimant. Only one injured person died. Lordship, and the matter already
After the disposal of this appeal.
Yes, Lordship. Disposal. I have stated paragraph 2. Lordship, initially disposed of 15th May 2025. Then few correction was made 18th. 28th July 2025, but Lordship's appellant expired on 7th September 2005. 2025. Sorry. 2000.
Yes, record and order. Learned advocates for the parties are present. This application, Can 3 of 2025, is taken out to record the death of the appellant claimant and to substitute his legal heirs. It is the contention of the applicants that the appellant claimant died pursuant to the disposal of this appeal on 7/9/2025, leaving behind the legal heirs and representatives, namely Manoshi Chatterjee, Sabyasachi Chatterjee, and Shomi Bandhopadhyay, as fully described in paragraph 3 of the application. Stop. This application stands allowed. Let the name of the appellant stroke claimant be deleted from the cause title and the names of the legal heirs as mentioned in paragraph 3 be substituted in his place and stead. This, the amendment be carried out by the department within a period of 2 weeks from date.
That's one thing, the money which has been allotted, awarded, that has been disbursed in the name of legal heirs.
My lord, I'll mention this matter before the previous bench, my lord, because there is some arithmetical mistake in the judgment. That's all.
তো পরে করবি ওটা কোথায় আছে
এটা কি বলছে?
Eight.
Anyway, let them be brought on the record thereafter.
Yes, lordship. Brought on the record and lordship.
So you are holding power for these applicants.
Yes, lordship. Lordship, the awarded amount should be disposed, lordship, disbursed in the name of present applicants.
So definitely, let it be corrected. After the necessary amendments are carried out, the awarded sum shall be disbursed in the name of the applicants.
I'm grateful.
Lord, there are three matters which are being heard together, 24, 25, 26. Lord, I just give you lordship, Lord, a very brief background, Lord, why these are taken up together.
My lord, one
Lord-
indulgence, item 26 is different from 24 and 25.
Very well, Lord, let me place it.
Item 20.
No problem. But I have
Okay.
prepared
You are appearing in which matter?
all matters for the petitioners.
All the matters.
Yes.
This Gopa Maiti and Devabroto Bag, you are appearing.
Gopa and Devabruta are husband-wife.
In all three matters, you are
All three
appearing.
matters I am appearing for the petition.
Another indulgence is in spite of your repeated, your lordship's request to petitioner, they have not served me, us with the reply. Till
Kiसी reply. তোমায় কেন দেবো? Opposition, person who has given opposition, we have given the reply to that person.
I should be served.
Why?
Because we are also answering.
No, question is, a reply is given to
To an
a
opposition,
particular opposition,
Yes.
affidavit in opposition submitted by a particular respondent. Okay.
I agree with your lordship, but still reply, I'm also another answering respondent.
you have not filed your opposition, you want the reply.
On what
It's
basis?
a
Because
movement and we are not being
I
direct.
mean, we shall do that. Let me place the case, we shall do that. These are all to delay it, Lord.
no, have you served copy of the opposition?
They have not filed opposition.
But
No.
by respondent,
Wow.
not been given direction to.
No,
file.
question is,
No, no, no,
the
no, that is there.
opposition filed by the respondents have been served upon you.
Yes, I have
Okay,
served.
then you serve the
Lord,
reply.
I tell you, Lordship, the private respondent, the de facto comp has filed an opposition to the writ petitions. The state has, Lord, may I just argue? We can't argue together.
Let this be clear. This will be clear. If somebody has filed an opposition, you have filed a reply, you have given the copy. But what your learned friend is saying is this, that affidavit in opposition and the reply is to be taken into consideration because she is also contesting.
We shall give them copy. Lord, we shall give them copy. Today
Let
the,
the case-
today the matter would not be over.
Okay, you will serve you in course of the day.
Lord,
Serve me in the course of. Kali record it, man.
মুশকিল বাবা মামলাটা শুরুই করতে দেবে না Now, Lord, kindly take, Lord, this list of date we have prepared for a Lord's kind consideration. Lord,
No copy has been served to me, madam.
give copies. We are not running away. List of date from the pleadings only. Copy them. Our copy kothay?
That is a document of the court you have to serve.
Now, Lord, just take, Lord, the দিয়ে দাও আর কপি যার যার চাই লিখে নাও দিয়ে দেবে এই তো দিলাম একটা তো যার ওকে বলবে তাকে দেবো তুমি তোমারটা দেখো yes not kindly have a look at note that there are see the identity of the parties not kindly come to the first page not 23635 filed by Gopa 27024 filed by Devabroto and not 27605 filed by Devabroto. Now Ardhendu was the victim. Now Lord Tumpa Mal, whom my learned friend Mr. Anjan Banerjee is representing, she is not the respondent number 6, 5 and 5 in all the writ petitions. Respondent number 7 is Pintu Bera. He is not being represented perhaps. Respondent number 13 is Julfikar Ali Molla. They have also not been represented. Respondent number 9 is Nirmalendu Rai. Now, my lord, what happened? I'll take your lordship to synopsis. What happened? I tell you, lordship, my lord. This Ardhendu Mal was a childhood friend of Devabroto. Lord, this is our case. Now, Ardhendu, Lord, was into the Devabroto, Lord, is a brick manufacturer. Lord, he owns a brick field. He manufactures brick and sells his, Lord, at the wholesale rate. Ardhendu had a business transaction. He used to, Lord, sell bricks in retail to the parties. Now, my lord, what happened? Ordhendu wanted to buy a house from one Gopal Haldar. Devobrota's wife Gofa is a lawyer of Uluberia court. Now he requested Devobrata that why don't you ask your wife to get the agreement executed. She got the agreement executed. Now, my lord, take the synopsis now. Can you take the synopsis? Devobroto is engaged in the business of brick manufacturing and seller at wholesale rate in locality of Sampur. Ordhendu Mal was a childhood friend of Devobroto who used to supply bricks and used to conduct business deals with Devobroto. During last 3-4 years, the said Ordhendu had purchased and made payment to Devobroto against supply of bricks through UPI system. In 2024, Ordhendu and his wife Tumpa showed interest to purchase the residential house from one Gopal Haldar. But I am not the owner, not the seller. Amount in rupees 38 lakhs, for which they sought for legal assistance from Devobrota's wife Gopa, who is a practicing advocate of Sub-Divisional Court at Uluberia. A registered agreement for sale was executed with the said Gopal Haldar on 7th March 24 before DSR 1 Howrah in the name of Tumpa Mal, the de facto complainant, upon payment of rupees 4 lakhs through demand draft. For completing the sale, Ordhendu and Tumpa sought financial support from Axis Bank of 34 lakhs and were approved on 13th August 24, but due to high rate of interest, they approached Punjab National Bank, who have also approved a loan on 2nd September for 30 lakh 40,000. On 4th September, Ordhendu at around 9:30 am came to meet Devobroto and his wife outside their residence in order to proceed with the preparation of the final registration of deed of conveyance of the property. However, he left after a brief visit, during which a common friend, namely Sosti Patro, who was also present at the scene. Later on, at around 6 p.m. in the evening, Devobroto came to know from the nephew of Ordhendu that Ordhendu has tried to commit suicide by consuming poison, and Tumpa and her associates took Ordhendu Mal to the hospital, which is 22 kilometers away, by a toto. Immediately, Devobroto, the petitioner, called one chauffeur-driven car, Maruti Wagoner, for taking Ordhendu to hospital, along with Sosti Patra and Onum Mondol, all friends, and their family members had taken Ordhendu to Sharad Chandra Medical College and Hospital, Uluberia. But unfortunately, Ordhendu expired. At the relevant time, his family members, including wife Tumpa, tried to take away the body of Ordhendu without completing the post-mortem examination. In view of suspicious circumstances, Devobroto, along with friends Sosti and Anup, ensured that the body would not be cremated without post-mortem examination and compelled the family members of Ordhendu to conduct the post-mortem examination. Suspecting unusual circumstances, Devobroto lodged a formal complaint on 7th September alleging that due to an illicit relationship of Tumpa with Pintu Bera, who is a Toto driver, the said Ordhendu has committed suicide. Since respondent police authorities did not register any FIR, despite the complaint disclosing cognizable offense, Devobroto filed WPA 27605 of 2024 seeking registration of FIR in the said complaint. 27605 কত নম্বর item? 27605 is item number 26. That is filed by Devobroto for registration of his complaint. Nothing has been done in that. Then, subsequently on 9th September, Tumpa, along with her political associate, attacked the residence of Devobroto and Gopa, blackmailed them with the help of Julfikar Ali Molla and Nirmal Roy, due to which Gopa was constant to lodge a complaint on 9th September and 10th September. Since no action was taken by the police authority, Gopa filed WPA 23635 on 12th September. But this is item number 24. On WPA 23635 was taken up for hearing on 1st October, when for the first time the police authority revealed that 1st October that an FIR has been lodged on 16th September pursuant to the complaint on Tumpa. Upon such fact being disclosed, Honorable Court was pleased to pass an order directing no coercive steps against Gopa. Lord Kali, pause here for a moment.
This after how many? So after the date of this,
Date was on 7th September. On 16th
when the writ application was moved.
Before that.
No. For inaction of the police authority.
Lord, there are two writ petitions. 7th September, Devobroto lodged a complaint. The day when Ordhendu passed away, no steps were taken. He filed a writ petition. Number one. Then on 9th and 10th September, their houses were attacked. Gopa moved a writ petition. Gopa writ petition came up for hearing on 1st October. Gopa petition on 12th September. It came up for hearing on 1st October. During the course of hearing, the state informed that after 9 days of death of Ordhendu, his wife has lodged an FIR. 12 days. Fourth he died. Wife lodged an FIR. Lord, what happened? Justice Bharadwaj, hearing that, Lord, directed that no coercive steps should be taken against Gopa. Although that FIR was not even under challenge. Gopa's writ petition is item number 24. Devobroto's writ petition seeking registration of FIR is item 26. What is item 25? Devobroto filed a writ petition seeking quashing of the FIR, which is lodged by Tumpa. That is item 25. Now, kindly allow me to place it. Lord, I have made this for your lordship's convenience. All are from record. Thereafter, Devobroto challenged the FIR before this honorable court in WPA 27024. That is item 25. During pendency of the Eastern writ petition, Devobroto was arrested on 27 September. Lord, kindly see.
That is paragraph?
Lord, page 5, paragraph 3.
Yes.
Lord, just kindly let me inform your lordships. Devobroto challenged the FIR. We mentioned it before Justice Bharadwaj. Justice Bharadwaj kept the matter on 28th of November. On 27 November, Devobroto was arrested. During the custody of Devobroto, Sampur police station initiated an FIR being FIR number so 1st December and pray before the learned court below asking for police custody in the said police case. No, they wanted to soon arrest. While considering such prayer, learned court found that the said case has not been initiated against Devobroto, as the name of the father of the accused in the case is different from the current Devobroto, due to which learned court deprecated the action of the police authority. Subsequently, Devobroto was enlarged on bail. While I was in custody in connection with the FIR which is under challenge in item 25, they wanted to soon arrest.
Which case? The other case?
In some other case where my father's name is different. New another case. Lord, the magistrate initiated an inquiry against the police officers. Parties have exchanged their affidavits in all the 3 writ petitions, which are now ready for hearing and to be taken together for consideration. Now, Lord, I have prepared a list of dates. The list of date is in detail. Lord, I have also prepared a list of documents because I need to, Lord, take your lordships from, because several papers have been annexed in the 3 writ petitions. What I have done, I have prepared a compilation of document. And I believe my learned friends have to go through this document. Lord, I'll be very unjustified if I not invite your lords to look into this. This is the compilation of documents so that my lord need not look into all the 3 writ petitions. I'll only take your lords to the compilation. I'm filing it. I am giving copies to my learned friends so that they can come ready. Just have a look at the compilation, how I have prepared. একবার দিন তোরা জোসেফকে সিদ্ধার্থ একটু দেবে? আমি তোমাদের কপি দিচ্ছি। আরে হাঁপিয়ে পড়ছো মামলাটার জন্য?
মামলাটার জন্য মানে কপি না দিয়ে তো রিপ্লাইটা
আরো কপি দাও। কে পায়নি তাকে দাও।
এরকম
দিচ্ছি ওর নাম্বার নিয়ে নাও। Just take the compilation once. Kindly come to in page Roman 1. রেডি হয়নি, এত বাজে কাজ তো। রেডি করিস না কেন? কপি সাফিসিয়েন্ট। Just see, just once. Just see.
Page 1.
Page 1. Just see. List of documents on behalf of the petitioner. Agreement for sale dated 7th March, executed between Tumpa and Gopal. Lord, kindly see pagination in the writ petition. The middle column, annexed in page 20 to 36 of WPA number 27605 and annexed in page 28 to 34 of WPA number so page number 1 of the present compilation. So, Lord, I will take your lordships only to the compilation so that it is become easier for all of us to, Lord, assist your lordships, Lord, so that we need not, Lord, travel on the all 3 petitions. So, Lord, what I am requesting your lordships, today I am giving them a copy of the compilation. Let them check it with a list of date.
Maybe some documents are relevant but missing.
Yes, they can also point out, and all documents, whatever are part of the records you have given. Lord, my submission in the nutshell is, I tell you also what happened thereafter. Lord, Tumpa has filed a suit. Lord, what is the complaint? Which is under challenge? Tumpa says that in order to purchase that house from Gopal Haldar, her husband came to me, Devobroto. Devobroto started asking money in cash. Devobroto had taken 60 lakhs in cash from Tumpa's husband. Initially, the FIR was lodged under 302. Thereafter, the charge sheet has been filed under 306. The allegation is that I have been abetted in his suicide. That's the allegation. And what is the allegation? That I have been asking for money of 60 lakhs I have taken for purchase of the house in cash when the agreement is of 38 lakhs. He paid 4 lakhs to Gopal, paid for a loan of 34 lakhs. Kindly appreciate. I wanted to buy a house from him. The agreement is of 38 lakhs. I paid him 4 lakhs. There's an agreement. I went to bank to apply for a loan for remaining 34 lakhs. And in between, the allegation is I have paid my friend 60 lakhs for buying a house of 38 lakhs. Now, this is not the end of the story. This is the malafide. Then what? Tumpa goes and files a suit for specific performance against Gopal Haldar. There, Tumpa says the value of the house is 38 lakhs. Sole allegation is that Devobroto was forcing Ordhendu and taking money from Ordhendu for purchase of the house from Gopal Haldar. There was a registered agreement.
This person, this Devobroto, as a intermediary.
They are saying, we say he is my friend, but their story has to be some sort of believable. There has to be some cause of action. Is it believable? May I ask this question to myself? I go to Mr. Mondal. I want to buy his house for 30 lakhs. I enter into an agreement. I pay 4 lakhs in advance by bank draft. I go to bank, apply for 34 lakhs loan.
So any documents was given showing transaction between this victim and this deceased.
Yes, the transaction is 180 rupees, 300 rupees, 500 rupees, 5,000 rupees, 7,000 rupees from last 5 years.
These documents were.
Police has not
seized those documents.
But we have produced because the allegation is I have taken money. Now it's my duty to come clean to your lordships. What is the allegation? I am the manufacturer of brick. He is the seller of the brick. Whenever he got order for 100 brick, 200 brick, 500 brick, he sent money in UPI. 76 times. So kindly appreciate, my lord, I want to pay Mr. Banerjee some money for buying of a house. Would I pay in 76 tranches or would I pay in 2,000, 3,200, 180? I have annexed all this in the document. But just take one page of the compilation.
There was business relation between the victim and the.
Yes.
Business relation is admitted.
Business relation is admitted.
But regarding the other one, that is to purchase that immovable property, whether he acted as an intermediary or not.
My lord would kindly come to page 18 once of the compilation. 18, 18 number. Just to show. It's a copy. Just come page 18, 18. Now, this is the entire, we have annexed the entire bank transaction. This is the transcript. Now, kindly take column number 19, column number 8. He paid me 100 rupees. Would anyone pay me 100 rupees for buying a house? Now, column number 19, he paid me 250 rupees. 1,200 rupees, 5,000 rupees, 10,000 rupees, 8,000 rupees. 2,200 rupees, column number 35. Then kindly see on the right hand side, 76. This started from 2nd March 2022 till 30th May 2024. The allegation is in the FIR. FIR page. Just I'll show one line since I have taken your lordships here. Kindly come to the complaint that your lordship will get at 147. Kindly come to 147. Prima facie malafide. The complaint dated. Sorry, my lord, 153. Just come to 153. Kindly come to the complaint. Page 154, which is quashing has been sought for. My lord, page 154. আমার নিবেদন এই যে আমি টুম্পা মাল স্বামী অর্ধেন্দু মাল সোয়াংশো বাসিন্দা হইতেছি আমার আপনার অবগতির জন্য জানাচ্ছি আমার স্বামী অর্ধেন্দু মাল এর সহিত 2 বছর আগে আপনার শ্যামপুর থানার অন্তর্গত কি নাম এটা খাচুরিয়া অঞ্চলের কৃষ্ণপুর গ্রামের অশোক বাগের পুত্র দেবব্রত জমি কেনা বেচা যোগাযোগ করিয়া থাকে। So this was lodged on 16 September 2024 at the top. So he says that we have contacted 2 years back. So 16 September 2022. Now page 18 says, no, then let me read one paragraph thereafter. করিয়া থাকে অদ্য হইতে প্রায় 1 বছর পূর্বে উক্ত দেবব্রত শ্যামপুরের জনৈক গোপাল হালদারের বাড়ি সহ জমি দেখাইয়া আমার স্বামীকে উক্ত বাড়ি সহ জমি কেনার জন্য প্রস্তাব দেয়। So the proposal for buying the house was given 1 year back, 16 September 23. Kindly come back to page 18 again. See the first transaction. Page 18 again. So the cause of action, if I believe whatever has been said, that I have started taking money from 16 September 23, the day I introduced him with Gopal, first transaction of 2nd March 2022. palpably malafide. Lord, we'll demonstrate everything. Now, my learned senior friend wants a copy of the reply. I don't want to, Lord, hoodwink and get an order.
What was the steps taken by the police authority pursuant to the direction in the writ petition?
Lord, the writ petition, here the writ petition, that
Earlier, to direction upon the police authority to start a case.
there was no direction, Lord.
No, writ petition are the very first writ petition.
No, nothing has been done. That is pending. Lord, 3 writ petitions, one filed by Devobroto seeking registration of the FIR on his complaint.
That was not decided.
Nothing decided. What they, Lord, kindly appreciate something. I'm so grateful to your Lordship. Devobroto alleges that Ordhendu committed suicide because his wife.
By Devobroto on the very next day lodged a complaint.
Yes. Now, what was the allegation? He said that my friend has committed suicide because his wife was having an affair with some Toto driver. Police has not even looked into that angle. Tumpa lodges an FIR saying that Devobroto was asking for money after 12 days, asking for money. Police has gone on to that. Lord, after filing the petition, so my first complaint has not even been looked into. That angle has not even been explored by the police. How could they have, what kind of an perfunctory investigation is this? Lord, first complaint, 4th he died, 7th Devobroto lodged the complaint, saying that there is some mistake, some illegality in the death of the Ordhendu. Please investigate. His wife was having an affair. He committed suicide. That has not been looked into. After 12 days, Tumpa files the complaint saying that my husband was killed by Devobroto. I have not placed the entire complaint. Complaint was that I have forcefully not put poison on his mouth and he died.
Investigation was done.
Yes, in the complaint of Tumpa. In the complaint of Tumpa.
Investigation was done.
Done. It has been filed under 306, not under 302.
Anyway, but the court cannot proceed with due to the pendency and stay order by this court. The trial court cannot proceed.
No, there is no trial court is proceeding. The charge sheet is under challenge before there is no stay. That is the urgency.
Huge amount has been transferred from the husband.
So is it a proceeding?
Means for this is 306.
306.
That means examination of the witness has started.
Yes.
The trial has not started.
Trial has not started.
They can file a discharge application there if they have a very good case. Huge amount has been transferred.
No, this is not a case of misappropriation.
Yes, is it a case of recovery of money?
306.
Yes.
They are pouring poison.
No.
That's why the
it is under 306. Okay, charge sheet is submitted under 306.
Yes.
That is why I was inquiring whether that is continuing or not.
Next date is in January before the trial court. January.
This charge is already framed.
Exactly.
Charge has not yet. Judge sheet has been filed, and copy. We have got the certified.
Committed to sessions.
No, not committed. We have got the certified copy.
Anyway, the moment the charge sheet is submitted, the cognizance is taken.
Cognizance, I'll have to check. Cognizance
already taken.
Only thing is commitment. The matter is not committed to the
not committed to the court of sessions. The charge has not been framed.
And this present writ petitioner appeared before the trial court.
Yes.
Appeared trial court. Did they obtain any regular bail or just?
He was arrested. Devobroto was arrested and thereafter released on bail. There is
this particular 306 case.
306 case, and there is a protective order passed by Justice Bharadwaj.
No. After being released on bail.
Yes.
So in that case, no further question because he is on bail.
He is on bail. But with regard to Gopa, your Lordship's court has protected Gopa, saying that there should be no coercive steps against Gopa.
The charge sheet is submitted against her also. In that 306.
Total against 3% charge sheet has been submitted.
They are appearing before the trial court with this protective order.
Yes. Lord, I tell your Lordship, the charge sheet has been filed. We have got the certified copy. We have produced that before your Lordships. We have challenged that also by a supplementary affidavit. When the writ petition was filed challenging the FIR, in the meantime, charge sheet has been filed. We have produced that in the supplementary affidavit. Very well. We'll show that. If the case is absolutely
in charge sheet,
baseless,
find various documents has been seized.
Okay, I shall also
cannot
see
escape from his
yes. Lord, there was an order for production of the CD.
Yes, that I shall see. Let me after hearing you.
Yes, there was already an order for production of CD, Lord. Lord, what I was most humbly saying, since my learned friend is saying there's a reply she wants to look into, what we'll do is today only or by tomorrow we shall supply all copies to all lawyers. নামগুলো নিয়ে নাও, এটা যেন রিপিটেড না হয়।
লিস্ট অফ ডেট এখন দিয়ে দিয়েছি।
তুমি আবার দিয়ে দেবে by letter, give it to everybody, so there will be no confusion with regard to service. My lord gives us any next date, will come and argue. Now the sum and substance of my argument would be this case, Lord, there is no material at all. There is no Lord, commission of any offense. There is no there is no cause of action for filing the FIR, and the investigation is absolutely perfunctory. So it will end to no result.
Petitioners are implicated under 306.
306.
And also, my lord, in second writ petition is concerned, my lord, I will submit before your lordship whether the writ petition is maintainable or not.
That he will argue. That he will argue.
After filing charge sheet, my lord.
They will argue. There is no problem.
Whenever they are appearing before the court.
Yes.
In procedural matter is concerned.
They will argue, my lord.
So I shall keep it next week.
My lord,
Whenever your lordship's diary permit.
in December, my lord.
Yes,
Next week to December hi hocche.
Early December. Middle hole bhalo হয় লেখাপড়া করতে পারি।
Oh, middle this bench may not sit for 2 weeks.
And the date is in January, so I'll if my lord, after your lordship starts hearing the matter.
Yes,
We are
record
waiting
an
for
order.
2024.
Learned advocate for the parties are present.
নামগুলো দিয়ে দাও।
Hard learned advocates.
হয়নি আদিত্য,
সবাইকে দিয়ে দিয়েছি।
নেক্সট যেন শুনতে
The
না হয়।
learned advocate for the writ petitioner
রিপ্লাই তো দেওয়া হবে।
in all the 3 writ petitions have submitted written note compilation
along with synopsis and list of dates.
list of dates and synopsis of the case upon copy with a copy upon all the learned advocates.
আমার জানার দরকার নেই, নেক্সট
Let
ডে
this
নোবডি শুড
matter
কপি পাইনি।
appear on
এটা তুমি দেখে নাও।
দাদা একটা
5.
তোমার জন্য তো ভাই সব ছেড়ে দিয়ে আছি। কত
Yes, I'm keeping it on 5/12. Friday week, Friday week.
My lord, Friday, my lord, I have some difficulty, my lord.
No, not this Friday, Friday
No,
week.
Friday, December, my lord. Next week.
12
Up.
দেখো না
12, I have no difficulty.
In the meantime, reply.
12, my lord.
Yes, 12.
12 no, I'm not 12 December. My lord will only take it up on Fridays or Thursdays also.
The dates I cannot assure you. Only these part hard matters are usually taken up on Friday.
No, 5th December would it be at 2 p.m.?
Is that I can
December, my lord, it is
5th December.
my lord, difficult, my lord. I have some personal difficulty. my lord.
Okay.
My
Acha.
daughter's birthday.
ছাড় না ছাড়।
ডটার বার্থডে তো
এই জন্মদিন
দেখুন তো
তাহলে কি করব?
তারিখে কিছু ফিক্সড আছে কিনা?
তাহলে তুমি 12 পরের ফ্রাইডেটা দেখো।
সেটা ছুটি পড়ে যাবে। 11 ডিসেম্বর দেখো না সিদ্ধার্থ দা।
Just a minute. 9 তারিখে দেখুন কিছু ইয়ে।
9 তারিখ না, 9 তারিখেও তো সমস্যা।
9 তারিখ 2 PM আছে।
11th
অরিজিনাল সাইড না অ্যাপেলেট সাইডে?
11th would be very convenient.
11 তারিখে নেই না? 8 তারিখে নেই।
8th in the morning, Lord. Or 11th if your lordship diary permit, Lord, it will be very হবে না সিদ্ধার্থ দা? 11th 10th
মর্নিং এর রোস্টার সেকেন্ড জাহির আছে।
in the on 8th Monday morning.
আসলে
8 তারিখে 12টার সময় দিই। I'm keeping it on 8th of December at 12 PM.
12 p.m. My lord, 12 p.m.
Matter appear on 8/12/2025 at 12 PM.
So grateful to lordship.
Reply to affidavit.
The copy of the replies and affidavits which are filed be served upon all the
For
parties.
opposition, we cannot supply. That is Mr. Banerjee has filed
No, if
opposition.
they have filed their opposition,
Already
they have
supplied.
to.
Supply.
I have supplied.
Opposition supply.
So you have supplied.
Yes.
Anyway,
There was no
because of
reason.
the opposition replies if not served, be served.
There was no reason for him to supply the opposition to the state. I don't know why. Maybe they are supporting each other.
It's a common.
What supporting? That is.
No. What
this
supporting?
sort of-
But I'm extremely.
We are not expecting from
Anyway, let things be transparent.
Yes.
be transparent.
I'm grateful to you.
So I'm also contesting party. Impleted me party.
Just one indulgence, my lord. I have already served the copy of the list of dates and documents, my lord, to all the parties,
I've
my lord.
made only affidavit in opposition and reply.
My lord.
I've recorded that. We have
Now,
submitted.
if my lord reply, I will serve, my lord. I shall serve on the
Only-
course of the
only
day, my lord.
opposition and reply if not served.
On the course of the day, my lord. I shall. Then,
হ্যাঁ, একই order করে দিই।
আমি দিয়ে
দিকে
দিই,
analogous
আজকে
করে
দিয়ে দেবো।
দেবেন। হ্যাঁ? হ্যাঁ। না না 1 PM হয়নি তো এখনো একটা হ্যাঁ আছে তাহলে ডেকে দিন কল দ্য পাস ওভার ম্যাটার
Yes, sir.
Yes,
My lord, in this matter, my lord,
yes, you are agreed by the grant of this interim compensation.
session, ma'am.
Yes.
My lord, to this effect, my lord, may I submit one thing? May I
Yes.
submit one thing? My lord, as per my instruction from my client, my lord, there is a talk of compromise between the parties. So, my lord, at present, my lord, may I pray for interim stay over the impugned order, my lord, in the
Okay, I am
meantime-
at, in order to grant stay, I have to admit the matter and thereafter grant stay. Now regarding which provision, regarding this interim compensation, let me see that.
Yes, sir.
If both parties would have been here, I would have sent it to mediation. Yes, which provisions you are relying in the, yes,
143A of NI.
143A, yes. So 10% of the check amount was given.
Was given.
How much are you ready and willing at present?
But at present, my lord, for the petitioner, my lord, it is not possible to him, my lord, to pay the interim compensation. My lord, what happened is the check, what has been issued by the petitioner to the complainant, my lord, it was a security check, my lord. Security check was given in order to assurance purpose, my lord, not for its consideration or any kind of presentation.
Question is that will be secured, not that you will have to pay the other party. It will be deposited. And if you succeed, you will get that back.
Yes, my lord, but my lord, as per my instruction from my client, my lord, at present, my lord, it is not possible to him, my lord. My lord, whether the check, what has been issued by the petitioner, whether it was security check or not, my lord, that is the course of trial, my lord. Let the trial be done. At least, my lord, interim stay is kindly be given. Well, if it is certain that the security check has been given by the petitioner, my lord, then, my lord, the 138 NI Act will not even maintainable.
Yes, record an order. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. The petition is directed against order dated 24/4/2025 passed by learned judicial magistrate 8th Court, Calcutta, wherein the petitioner was directed to pay interim compensation of rupees 14,25,000, which is 10% of the check amount. Stop.
My lord, here may I submit one thing, my lord?
Yes.
My lord, the check amount is, my lord, 17,63,000. My lord, the order itself suffers from irregularity, my lord. Your lordship kindly.
The check is how much?
Check is, my lord, 17,63,000.
17 lakhs.
Order does not tally with the 138 application. Your lordship will find it at page 10, my lord, of the 138 petition. The check amount is 1,763,288.
Yes.
And here, my lord.
No, right. Then that is 14,25,000 in favor of opposite party number 2 within 60 days from the date of the orders. Learned advocate for the petitioner draws attention to the complaint petition, paragraph number 10, wherein the check amount is mentioned as rupees 17,63,288. Stop. Learned advocate submits that although the check amount is 17,63,288, but the learned trial judge has made observation that the check amount is rupees 1,42,50,000. Learned advocate also submits that considering the irregularities of the order passed by the learned magistrate and considering the grounds, this matter be admitted. Upon perusing the order dated 24/4/2025 and the paragraph number 10 of the complaint petition, it appears that the check which was dishonored, that the amount mentioned in the check which was dishonored does not tally with the check amount mentioned in the order of the learned magistrate. Stop. Upon perusal of the order of the learned magistrate, it appears that due to the delay caused by the accused petitioner, the interim compensation was awarded. Stop. In the instant matter, although the case was instituted in the year 2020, but considering the fact that 2 years was a COVID period and subsequently the Is the matter ready for trial?
Yes, my lord.
And the case at present is ready for trial. This court is of the view that this application should be admitted. Thus, I admit this revisional application. Let notice be issued upon the opposite parties within 7 days, and affidavit of service be filed forthwith. Let the matter appear before the regular bench on 16/12/2025. Pending hearing of this application, there shall be a stay of further, there shall be a stay of the order dated 24/4/2025 till,
My lord, may I pray for until further order, my lord?
no, the matter will appear before the regular bench. You obtain an extension there. The stay of further orders till 2/1/2026.
My lord, the next date is, my lord, 14th January, my lord. My lord,
But prior to that, you will get it. You will get your petition heard.
it's not possible, my lord. At least, my lord, after 14th, my lord, 14th of January, still extended.
For a period of 3 weeks from the date of reopening after Christmas vacation.
My lord, there is a CRAN application, my lord, 90 days delay is there.
Oh. Then you see, if there is a CRAN application, then this application cannot be disposed without hearing the other side. Have you served copy of this application?
Yes, my lord. Yes, sir.
Where is the affidavit of service?
The affidavit of service, my lord, I have not.
Then that means entire order will go, because without allowing this application after service, I cannot take up this matter.
My lord, the affidavit of service is not with me, my lord. My lord, kindly grant me one day time, my lord. Tomorrow I will come.
Okay. Okay, I'm just making it not today.
Yes, my lord. Tomorrow I will come, my lord, with the service.
Yes. Yes, both the matters not today. দেখে দিন ওর কি হয়ে গেছে না ফিক্সড অ্যাপ্লিকেশনের দিন
My lord, I am for the appeal, and my lord, it is insurance company's appeal, my lord. 29. No. NICL versus Ashok Kumar Singh. My lord, I have deposited the statutory amount of 25,000, my lord. I am handing over the slips, my lord.
Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 26th August 2025, passed by the learned Judge Bench 4, City Civil Court, Calcutta, in MSC case number
417 of 2018.
MSC case number 417 of 2018 for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest from the date of filing of this claim petition till date of deposit, excluding the statutory deposit within this period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Liberty to mention.
Grateful, my lord. My lord, the direction may be given for serving the copy of the memo on the opposite parties, my lord.
Yes. The appellant shall take steps to cause service of notice upon the respondents through the department. Let this matter appear on 8/1/2026.
My lord, first may I serve, my lord, if they do not come, then through the department. my lord.
Whatever it is, you serve to the department, you take both. The appellant is also granted, Likun, the appellant is also granted liberty to cause service.
By postal, my lord.
Yes, through post.
I'm grateful. Extremely grateful.
At number 30, Lordship, I am for the claimant respondent, and Mr. Somalo Ganguly for the appellant is the Magma. Lordship, I have prepared the paper book and that I have served upon Mr. Ganguly. So you kindly accept this paper book that I have served already.
Lordship, I'm there for the appellant. I'm
So Lordship, kindly I have two full pairs. One fold is pair is that I am filing the paper, also kindly accept that, and another fold of pair before is that I have filed one cross objection, that is COT number of COT number 138 of 2025, that has to be tagged along with the mail.
Yes, record and order. Learned advocates for the parties are present. Let the paper books filed be kept with the record.
And that has been served. Record that I have already served.
The matter is ready for hearing. Stop. As this is a motor accident claims case, and the matter may be settled by sending through the to the Lok Adalat.
It is not possible, Lordship.
Okay, the matter be sent to the Lok Adalat to be held in the month of December. Fix 8/1/2026 for report of the Lok Adalat.
It will go and then immediately it will not come.
Yes, in the month of January.
Lordship, kindly, Lordship,
Yes.
kindly fix the date for logically hear the merit of the appeal. If Lordship will thinks it, when Lordship will send down on February.
You see, you take instructions from the insurance company with regard
He's
to
not the advocate on record.
You say the advocate on record to take instructions from the insurance company.
My humble
for the purpose
submission
of
is that
settlement.
kindly record.
No, why the records will not come?
Court is not with the appeal.
Acha, let this appeal along with COT
138 of 2025.
138 of 2025 be tagged along with this appeal.
Along with the appeal. Lordship, I did not talk. Lordship, it will go immediately on to come. Lordship, hear the appeal on merit, then Lordship will think.
Question is, if it is not settled, you mentioned the records will be immediately called.
Very well, Lordship, kindly fixed on Monday along with the court and fix the matter on that day. Lordship, pass the order.
I'm keeping it in the month of January. Okay.
No, Lordship, kindly take it on Monday.
Which Monday?
This Monday, Mr. Ganguly will present. On that presence, Lordship will decide direct that.
It's better they hold. Today
only my prayer to tag with the court along with the main appeal. So Monday will also hear the appeal, and if Lordship,
I'm not hearing. All hearing matters will be done in the month of January. Okay.
It will not happen.
Very well. If it does not happen, there are many matters which are sent. I'll take it up in the month of January. Yes, take it in. Is any other urgent matters? 32.
31.
Call code the list. 31.
31. 31, my lord, I'm for the appellant.
33, my lord.
31, my lord.
31.
Yes, my lord. This is application for limitation.
My lord, I am of the respondent opposite party. My lord, what happens, my lord? Two applications have been supplied to me on the on the last officer. Application number 5, can number 5 and can number 6. One, my lord, leave to prefer
appeal,
and another, my lord, injunction application.
Yes.
Those two applications have been subsequently filed, and copy of the same has been supplied to me only.
My lord, injunction, the question of injunction.
My lord, the applications which have been filed, my lord, the appeal has been preferred against the, my lord, dead man.
Dead man, but my lord, all the persons are all record.
Subsequently, my lord,
they have suppressed.
That the person dead. And
that is why she has taken out necessary application.
Yes, my lord.
Which application you want to file?
My lord, let me to start, my lord. Let me to start. For 1 year, my lord, they have taken time.
No, item now. No, which application you want to file your affidavit in opposition?
Application 5 and 6.
My lord, 5 and 6 is not required. 6 is injunction application.
Allegations have been framed against us.
Yes.
And my lord, that's why you have to, my lord,
No.
My lord, keeping.
What is this can 1 for?
Can 1 for the limitation, my lord.
Okay. So let this limitation application be taken up. No, but the question is, are the parties against whom the appeal is preferred, they are living or dead?
My lord, all the parties are on record, my lord. Only 3 daughters.
These According to you, this appeal is preferred against the dead person.
Dead person.
One thing is there.
One thing.
Yes.
So let this dead person be substituted first. This is the first thing. So has any application to that effect been taken out?
Yes.
Which is that application? Thereafter, I shall consider other.
Condonation of delay and there are
No condonation delay everything. First of all, let the dead person be substituted
Yes, my lord.
or be deleted. Where is that application?
2 and 3.
2 and 3.
Can number 2 and 3. He has given opposition.
Okay.
I have filed opposition, my lord, to that.
এটা ধরো এটা ধরো ওটা ধরো ওটা কি আছে রাখো 2 and 3. My
You want to file reply to this opposition?
No. Certainly not, my lord. My application for addition of party I have made because, my lord, the dead person.
See, which person has died?
Respondent number 9, my lord. Bimola Bala Sardar. His all the sons and heirs are on record, my lord, in the appeal.
We have filed,
Since
my lord,
beginning, my lord.
Just a
opposition
minute.
to that, my lord.
Where is that opposition? Let me see.
Yes.
Can number 2.
Affidavit in opposition for that.
No reply has yet been filed. I have added one.
It is not required, my lord. It
What is the ground for ground to oppose?
unnecessary by keeping
Long
pending of
before
this, my
the preferring
the entire property.
So, Bimola Bala Sardar died 14/1/2020.
Yes.
That means during the pendency of
No.
before during pendency of this appeal or prior to filing of this
Prior
appeal.
to that.
The filing of this,
Okay.
my lord, after serving
So that I am
this,
saying for a
my lord, let me to
against
submit
the
first.
person, the appeal has been prepared.
My lord,
One thing is
it has been written, my lord, in paragraph
there is
2,
enormous delay.
paragraph 2 of
No,
my
that I have not come. This section 5 I have not taken up.
Yes,
Only the substitution, because this record has to be rectified.
yes, my lord. Page 5 of application number 2, my lord. Page 5.
He is there, my lord. After the judgment and degree passed, my lord, it has been, my lord, affected for rectification of the record of rights during the pendency of the same.
That is on merits, okay. Now the thing is this, the appeal is preferred against the one of the respondent who is dead.
Who is dead?
Yes, record and order.
But he's all the record, all
Learned advocates for the parties that are present.
court.
The application can 2 of 2023 is taken up for consideration.
Yes, my lord.
This application is filed to delete the name of respondent number 9 who is dead. Stop.
Yes.
Hard learned advocates, it is the contention of the respondent number. Your respondent number?
What, 1, 3, 5, 7 and 8.
1, 3, 5, 7 and 8. That respondent number died prior to filing of this second appeal. Stop. Upon considering the submissions, this court is of the view that as Order 1, Rule 10(2) of the Code of Civil Procedure empowers the court to delete the name of a party who has been wrongly pleaded, this application should be allowed and the name of respondent number 9 should be deleted from the cause title of this appeal. Thus, this application can 2 of 2023 stands disposed. The department to carry out the necessary amendments within a period of 2 weeks. Liberty to mention.
And my lord.
No. After this is carried out, you mentioned.
My lord, let me to give 1, 2, 3, 4, and my lord 5. And
no, question is after this substitution is carried out. After this amendment is.
My lord, substitution, all the parties are in record. Why this?
The amendment, the procedure is to be followed. The department will carry it out, and after 2 weeks it will come.
After correction may be there, my lord, in the memorandum of appeal.
Yes, and the memorandum of appeal be corrected accordingly.
Well, only record may be done that all the parties, all the represent record.
That is not necessary. Okay, let this rectification be done.
Yes.
This can 2 is disposed.
Can 2 and 3.
No, not 3. Can 2 only.
3.
Can 3
Can
2.
3 is also substitution.
3 is what?
Substitution, my lord.
Let me see that.
Setting aside abatement and condemnation of dealing of these. As his prayer, my lord.
No, which party died?
Respondent number 9.
No, for respondent number 9, you see, these respondent number 9.
3 and 4 should be also
Question.
disposed of.
No, 3 and 4 are also dead. Respondent number.
Oh.
Respondent number 9 died. Delay was there. That is why setting aside abatement and condonation of delay filed by his prayer.
That is not, that is under challenge, my lord.
That is under challenge. How it can be? It is allowed.
No. So far, you see, actually, substitution is not applicable because you see, the case is instituted against the wrong person. So, had he been alive at the time of second appeal, the substitution would have,
Yes, it is corrected. How
because it is only the name of the person who is wrongly impleaded on the ground of his death be deleted, and the case be proceeded against the persons who are alive. So that is why I disposed this Can2 of 2023. The other applications will be taken up on the next day. All other persons are alive, all respondents.
Yes, my lord.
So no question, it will be
3
taken
and
up.
4 are related to this too, my lord.
Maybe they are on the record.
3 and 4, my lord. This is the application number.
No, 3 and 4 is for what purpose?
File number 3 and 4 filed for condonation of delay and setting aside abatement of this, that is a substitution application, my lord.
For deleting the name of.
Yes.
Yes, as the question of abatement does not arise because as the question of abatement and the delay does not arise because the persons, the other years are already on record.
Yes.
And the death of this person did not take place during pendency, the question of abatement does not arise.
Yes.
But the period of limitation regarding condonation, that our
Question is,
allegations.
the name is, the case is instituted in the name of person. So no question of abatement.
Yes, my lord. Grateful to your lordship. Now here.
So if there is if MB motor vehicle claim matters are not very urgent, it can be taken up on the next day, unless it is very urgent.
This is for default, I cannot find.
32 Just a minute, let 32 be called on. Yes, last matter.
Yes. My lord, I am appealing for the appellant, my lord. There is a deficit of court fee, my lord. Just today I have received the brief, my lord. Kindly give me this week time, I will submit the court
One
fees,
is
my
for
lord.
what?
One is for stay, my lord. I have already granted a stay, my lord.
For the respondent in the second appeal. There
Well,
is a stay of operation of the order, but they will pay occupation charge.
I am paying the
This
occupation
order
charge.
was passed in 22. My lord sitting is Mr. It was passed. I cannot proceed with the execution. I find after 2 years till date, court fees have not been paid.
If I have passed an order in the division bench, should I take up this matter?
No, now it is appeal.
The hearing
of that.
matter.
It's only admission. It's only admission. Hearing the matter. It is not my lord's order in per se.
So now the question is, deficit court fees is not paid.
Not paid for last
Within this week,
court
my lord,
no
I have
paper
missed the
book
order.
prepared,
At the
nothing
time
done.
of passing the order before the lodging, I was not present
The
there. my
matter was admitted with on the in spite of deficit court fees.
I don't know. They say the order of the magistrate. Maybe it was not brought to the notice of the court. Now the registrar administration has given a report also. The report is here in the file, must be.
lord. Within this week, my lord, I will.
Yes, that can be done, but it should be. I'm not standing in the way from putting in the deficit court
Yes,
fee.
yes, record an order.
But it should
Learned advocates for the parties are present. The learned advocate for the appellant prays for time to pay the deficit court fees. Such time is allowed. Let this matter appear on 5/12.
It can be on 4th or 8th, other than 5. 4th or 8th. It is a Monday and 4th is a Thursday.
Here on 4/12/2025. That means within 1 week you pay.
Paper book. They have not prepared the paper book yet. Because the order record, the LCR need not be called on now. The second appeal, the prescribed format, that the trial court record, the appeal court record, the memo on appeal, there's only 5 or 6 documents in appeal in the paper book. In a second appeal
paper books, if not filed, be filed in the meantime.
Or I can also do it done because I'm the
You
landlord.
require some time. You request some time to.
A week's time for me will be sufficient because they will.
Then I do one thing. Then I keep it in the month of January. You take your time.
Or she will do that. Let's come back on 4th. Let them put the court fees, deficit court fees. That's defective then. If the defect is cured, then we'll work it out how we will paper the paper.
Okay, I'm keeping it on 4th.
4th, yes.
But both parties.
The file be sent to the department to carry out the directions.
Order tag with the.
Both parties present, London present.
33.
33 both parties present. Yes. Only this is for the restoration.
Dekhi record ta dekhi.
My lord. But unfortunately, my lord, it is unfortunately, my lord, I am praying for my lord. My lord, first, my lord, I pray for apology, my lord. The matter has been dismissed for default, second appeal. Unfortunately,
Let me see.
But due to illness.
By the single bench or division bench?
My lord, single bench. By the single.
My lord, the restoration application was filed without condonation of the delay. The delay for 7 months already
No, no.
left.
Have you prayed for condonation of delay?
No.
Delay be
No.
condoned?
No, my lord. Nothing.
The application, my lord, you also can see the money.
The only restoration application.
No. In your petition, have you stated the ground for condonation?
No.
No, my lord, my lord. I have stated, my lord, the petition, my lord.
After how many days you have filed?
Lord, I filed, my lord, the
The order passed on
passed, my lord, 4th October
2024.
Lord, the Radha advocate, my lord, seriously ill.
Not all.
You also kindly see the, my lord, earlier order, bone,
My lord.
Kindly consider only, my lord, restore this, my lord, appeal and my lord, hearing maybe.
Kindly see order number, order dated 19th March 2024, 29th April 2024, and 14th May 2024. After that, 29th September 2004. In no occasion, the appellant appeared, my lord. And subsequently, ultimately the matter appeared on 4th April, 4th October 2004.
That is 700 days delay.
Yes, my lord.
No. 2024 it was.
Yes, my lord.
And filed 4/10/2024. No. Dismissed
This
for
is filed
4/10/2024. Where is the order? Dismissal order.
Yes.
Yes.
My lord, only my lord, appeal, my lord, this is for default. And my lord, earlier occasion, my lord, and friend, my lord, the lord who is appearing, my lord, he is seriously ill and bone injury.
The matter was appearing for what? Hearing?
No, my lord.
My paper book is ready.
No. When the matter was dismissed, it was appearing for hearing.
My lord,
yes. I'm ready for hearing.
On that day, it is fixed for hearing.
Last order, my lord, 4th October.
This appeal is not yet admitted.
Admitted, yes. Order 41 is
Admitted.
Order 41 admitted. Order 41 allowed. And my lord, paper book has been filed. And my application is ready for hearing.
4/10/2024. When did you file this application?
My lord.
Yes, July 2025. Yes, 8 months.
Actually, in 31st July 25, it is filed, my lord.
34th July, my lord. 31st July, my
lord.
Yes, record an order. A learned advocate for the petitioner is the learned advocate for the respondents are present. Hard learned advocates. This application is filed for recalling the order dated 4/10/2024, dismissing this appeal for default. It appears from order dated 4/10/2024 that the learned advocate for the appellants failed to appear, for which this appeal was dismissed for default. Stop. Also, learned advocate for the respondents objects to the prayer of the appellant. Although in this appeal is filed after the period of limitation. Stop. However, in this appeal, although filed after the period of limitation, but no application for condonation of delay is filed. Stop. However, as in the petition itself, the appellant's petitioner has shown grounds for delay and grounds for non-appearance of the learned advocate. This court is of the view that the delay should be condoned and this application should be allowed. Thus, this application is allowed. Order dated 4/10/2024, passed by the Honorable Justice Vivash Ranjan De, is recalled and this appeal is restored to its original file.
Yes, my lord.
My lord,
And my lord, return back, yes, I'm.
allow me
What
to
record,
raise
my lord?
one thing. In the last occasion,
Yes, my lord.
two learned advocate appeared, my lord. They did not appear, turn up. In the fourth day, this is a partition suit.
Anyway, for laches of lawyer, parties cannot suffer.
Without the applications, without the condonation application, my lord.
No, I have recorded that although there is a decision also.
This restoration application cannot be allowed.
No, you see, Section 5 of the Limitation Act provides
yes,
that court should be satisfied about the delay. In the petition, if he has explained itself, separate application is not required.
Yes, my lord. In the petition, they did not mention.
Whatever it is in what paragraph he has stated, that his knowledge.
My lord, yes.
No, my lord.
Lordship.
No, you see, this paragraph
they
he has
never
stated.
stated.
Yes,
They-
yes.
they were
Appellants
stated.
came.
When the
Yes.
collect the order.
Paragraph 9.
My lord, when they collect the order, see, their advocate is there, or they are ought to be.
You see, for laches of the advocates,
My
parties
lord,
should
it
not
is a
suffer.
partition suit since 2015.
Say what it is, what can be done? The parties do not come to court. It is their advocates who take steps. What can be done if the advocate does not come? They will be in a helpless situation.
No, my lord. One thing was.
Yes.
The respondents are the ladies. They are not.
Anyway, let this appeal appear for hearing.
Fine.
Okay. I'm keeping it in the month of January. How old is this appeal?
Date fixed.
Now, how old is this appeal? 2022.
22, my lord.
Let this appeal appear for hearing.
Right.
Appear for hearing on
Date fixed, my lord.
on 6/1/2026
My lord.
at 3 p.m.
My lord, yes, yes, yes.
Your Lordship, on item number 30, Your Lordship has passed an order wherein the stay needs to be made absolute. Your Lordship, that has already been interim stay has been given by the coordinate bench. The stay needs to be made absolute. I have deposited the entire sum. Item 30.
Okay, come at 2 p.m. I shall see.
I will.
Next matter.
Yes.
Next
Wait,
matter.
come at 2 p.m.
For judgment, item number 1.
Yes, I'm reading out the operative portion. Thus, this appeal fails and the same is dismissed. The judgment of learned additional district judge, first track, second court, Malda in MSC case number 94 of 2019 is affirmed. Respondents number 1, 2, and 3 are permitted to withdraw the amount deposited upon compliance of all formalities.
The interest is 6%.
Yes?
Interest 6%.
No, all. Entire appeal is dismissed. The entire order of the trial court is upheld.
The interest has been given 6.5.
Very well, there is no such bar, 6.5%. I've hold it.
I am the respondent. I am going for the appellant, my lord. Paperwork file হয়েছে ডিপার্টমেন্ট সব আছে
your order to remove the ticket.
ওটা ফাইল করেছি আমি আগের দিন তো বলতে গেলাম না সব আছে এখানে আগের দিন যখন ফিক্স হলো আমি বললাম তখন সব আছে $34
কত নম্বর এটা
This is an appeal at the instance of the defendant, appellant, a suit for declaration of title and injunction and recovery of possession.
Yes.
The suit was initiated at the instance of two cooperative housing societies
Yes.
against the defendant.
Yes.
Now, if my lord kindly comes to the paper book, page 171, at the time of admission of the instant appeal,
Page 171.
171.
Yes.
Yes, at the time of admission of the instant appeal, the Honorable Division Bench framed two substantial questions of law. If my lord sees, these were the two substantial questions of framed at the time of admission of the appeal, although I was not there at that time, my lord. But I will be humbly praying, my lord, since the entire issue is against a housing cooperative society, as per the West Bengal Cooperative Societies Act.
No, you are aggrieved by the order passed by the appellate court in dismissing the application for condonation of delay.
Yes, well, that is all. Although these were the two.
So this is the scope is limited. I have to hear only this point.
I am not disputing that, my lord. I am humbly praying, my lord. Other than these two issues, I will humbly praying an additional substantial question of law to be framed, since the issue is related to that. That is the only issue.
No, no. Here you see, the appeal is not dismissed on merits, simply on the ground of condonation of delay.
Kindly seize, my lord, once.
Yes.
Kindly seize.
Yes.
1024.
1024 of
West Bengal Cooperative Societies Act.
Yes. One zero
two subsection 4.
Yes.
Anyway,
you are challenging the jurisdiction.
Yes.
Whatever it is, you see, suppose your application for condonation of delay would have been allowed. You could have got the opportunity to agitate all the points. Now you could not get the opportunity. Now, if you can succeed in showing that the learned appellate court was wrong, you can agitate all these points.
In that event, I will be humbly praying if that issue is taken here also.
No, that issue cannot be taken. You have to confine your submissions with regard to the two issues framed. Had it been disposed on merits, I could have considered
I can
that.
understand, my lord, but at today's, as per the section 100 of the Civil Procedure Code.
Yes, the court can frame issues.
I will
100.
Subsection 5. The appeal shall be heard on the questions or formulated, and respondent shall, at the time of hearing the appeal, be allowed to argue the case.
Just a minute.
Provided that, may I hand it over?
No, I am finding it. Yes. Yes, formulated and the.
Kindly see the proviso clause. Provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded the appeal on any other substantial question of law not formulated by it, if it is satisfied the case involves the question.
This court can formulate the questions of law.
Additional question.
Yes, that can be done. But in this case, this is not a fit case to formulate, because only it is on the point of limitation. So you argue on the point of limitation.
Jurisdiction point can be taken out.
No, nothing. All this will be left open. You just justify, because you approach the appellate court. The appellate court has had jurisdiction. So you invoke the jurisdiction of the appellate court.
The appellate court did not.
No. Question is, the appellate court had the jurisdiction to entertain and dispose your appeal. Rightly or wrongly, whatever it is, the appellate court did not exercise the jurisdiction because on the ground of section 5, the appellate court found that your delay is not justified. So whether the appellate
I am not saying I will argue on that point also.
nothing is
Kindly allow me to argue.
no, you need not argue on any other point, save and except these 2 points. Yes.
Let this issue be added.
Nothing. No further issues.
Because the if my
you see, I am not deciding the appeal on the merits of the judgment of the trial court or the appeal court, because the appeal court did not hear on merits. So I shall not assume the jurisdiction of the appellate court. Okay, first appellate court. I shall confine myself to the second appellate court. Of course, second appellate court is on the points of law. So what the appellate court did, has decided, has confined itself to your section 5. So first of all, I shall consider whether that is valid or not. I shall not go into the merits.
That I shall
see that maintainability point is also on merits. You see, please, you just confine yourself to these 2 points.
Well, jurisdiction point can be raised.
Very well. I shall hold that. You argue.
My lord.
No other point, save and except these 2 points.
Kindly allow me to place 2 judgments on this.
I shall. You see, please, whatever you want, you argue on these 2 points formulated. No stretching further.
Kindly comes to page 88 of the paper book. Kindly first come to page 51, the application of section 5.
Okay,
let me place that first. Page 51 starts from 52.
Yes. So this is a suit.
Yes.
But section 5.
This is the application section 5.
Section 5, yes.
The respondents plaintiff institute a suit being title suit number so and so before the court of learned civil judge senior division at Adipur against the appellant defendant along with their mother. The then was alive, praying interior declaration that the plaintiffs Ponchoshire township converting the land described in Schedule C of the plaint includes also the A schedule, of which plaintiffs are owners and defendants have no right to use and occupy any part of A schedule or occupy the house in B schedule wrongly constructed by them. Recovery of khas possession of B schedule property by demolition and removing the house structures of B schedule thereof and evicting the defendants thereof. A decree of mean profit or damages against the defendant for wrongful use and occupation of the suit property from so and so till recovery of khas possession thereof, tentatively at the rupees eto, subject to final determination of same in appropriate proceeding by which learned court on payment of further court fee, all interlocutory reliefs, cost of the suit, and such other relief of which plaintiff are entitled under the law and in equity. The appellant defendants, along with their mother, entered appearance in the suit and contested the respondents' plaintiff's claim in the suit by filing their joint written statement. As a matter of fact, the original defendant number 2 was the mother of the appellant defendant number 1 and appellant defendant 2, whereas the appellant defendant number 1 is a brother of the appellant defendant 2. During the pendency of the said suit, the original defendant number 2, namely the mother Srimati so and so, died, and since all her legal heir and heirs were already on record, her name was expunged from the suit. It is that the appellant defendant number 1 who is looking after the case for the sales and on behalf of the other appellant defendants as stated above, and was taking steps in the suit before the learned trial court as per advice of his or the then advocate Mr. So and so. Since the year 2003 was ill luck who would have it, the appellant defendant became sick and for the time to time was admitted to Piazza's Hospital and BK Roy Research Center with the complaint of chest discomfort, underwent various medical tests, which revealed that he was suffering from the ischemic heart disease. Besides, he was and is hypertensive, diabetic, and dyspeptic. He was then under the constant treatment of the supervision of so and so in Peerless Hospital and BKRI Research Center. And as a matter of fact, he underwent coronary angioplasty. With such ailment, also as per the legal advice of his learned advocate, your petitioner so and so had to attend the court for recording his deposition under great hardship up to so and so, and when his cross-examination as DW1 in the suit was in progress. In fact, despite repeated requests ventilating his ailments and constant medical advice, was not to take his strain or stress or move outside the house excepting for emergency purpose. His cross-examination by the respondent plaintiff could not be completed till so and so. In this situation, when he examination was started, since that on a number of occasions during the deposition of the appellant defendant number 1 as DW1 in the suit before the learned trial court, further deposition was deferred at the instance of the plaintiff respondent. And ultimately on so and so, although attendance was filed on behalf of the appellant defendant in the suit, but DW1, namely the appellant defendant, could not turn up for his purpose of further cross-examination when the matter was called on for further hearing, as he fell sick in the court campus. Although he said learned advocate assured that he would take proper steps seeking adjournment on his behalf, considering his health condition, but it appears on record that nothing was done since the Hajira was filed, but the DW1, namely the appellant defendant, could not turn up. His deposition was closed by order of the learned trial court, fixing so and so as the next date in the suit for further hearing. On so and so, with the ill health and in spite of medical advice restricting the movement of the appellant defendant, he visited his learned advocate in his court's chamber, but he was informed by his sane learned advocate since on adjournment petition was filed on that day, the matter could not be taken up and it was adjourned. Next day could not be informed to the appellant defendant 1. At that moment, his learned advocate, when he assured him that he would inform the next date over phone. Thereafter, the aforesaid learned advocate did not inform the appellant defendant 1 about the next steps of the suit. But whenever the appellant defendant 1 on his own rang his learned advocate, he assured that he need not to worry about the next date of the suit, and it would be well informed to him whenever the appellant defendant 1 would require to attend the suit personally. Unfortunately, since the month of March 2008, the condition of the defendant appellant number 1 started deteriorating further, in as much as he used to feel chest pain on a little bit exertion, and his blood sugar was also not being controlled in spite of taking regular medicines. He was advised to take absolute rest at home and not to undergo any stressful situation. In the beginning of 2009, although his condition was gradually stabilized, but in the month of February 2009, he developed acute chest on the fever with yellowish discoloring of urine and his eyes, as well as loss of appetite. When he further admitted in Ruby General Hospital and referred to Dr. So and so and so and so, he was diagnosed to develop acute viral hepatitis E with so and so. He was further treated conservatively and discharged on so and so, with the advice to take rest at home and frequent checkup by so and so. In the second week of June 2009, his bilirubin level became within the normal limit. Blood sugar is controlled with regular insulin and became free and from his chest pain. When he was advised to resume his normal activities following medical restrictions by the medical advice and on certificate dated so and so by so and so, after having been resumed normal duties and activities, the appellant defendant number 1 immediately contacted his learned advocate on so and so at his chamber. And to his utter surprise, he received the news the suit in the meantime decreed against the defendant appellant in absence of the representative on behalf of the appellant defendants. Since February 20, 2008, on which date no steps were taken on behalf of the defendant in the suit. Following the next day on so and so, when the argument was taken up on behalf of plaintiffs, it continued. But on the next day so and final judgment delivered on 19 March 2008. The appellant defendant came to learn about learned from his learned advocate that no steps was taken by him on behalf of the defendant in the suit since February 2008. Your petitioner states that he reposed confidence upon his said learned advocate on record in the suit, who assured all time appellant number 1 during his ailment that he need not worry, that he would take proper steps in order to protect the interests of defendant in the suit. But on record, it reveals otherwise, as neither he informed nor intimated your petitioners about the progress of the suit since his last visit in his chamber at Alipur Judges Court campus and so. Nor he took any steps and or proper steps on behalf of the defendant on record before the learned court below. As a result, it ultimately went against the interest of the defendant in the suit, inasmuch as the learned court below observed in the judgment the defendant and or DW did not face cross-examination on behalf of the plaintiffs, although the cross-examination was of DW1 was recorded in part. In absence of the petitioners, because of his prolonged illness as well as due to negligence and or inaction on the part of their learned advocate on record in the suit, the case on behalf of the defendant appellant could not be represented before the learned court below, and thus judgment and decree of the learned trial court appealed against, affecting harshly against as well as the prejudicial to the interest of the appellant's defendants. As a result, which appellant's defendant immediately contacted his learned advocate with the certified copy of the judgment and decree, which however delivered to your petitioner on so and so. By this time, erstwhile learned advocate and the present learned advocate instructed to prefer appeal against the judgment and decree of the learned court below. On perusal of the papers as well as judgment and the decree and readily of the memorandum appeal was preferred by the present advocate of the plaintiff on so and so, which was settled and approved by the senior counsel on behalf of the petitioner appellant on so and so. In fact, the instant appeal was filed so and so before the learned court. Your petitioner states that he had fallen sick and had his erstwhile advocate not acted against the interest of your petitioner, petitioner reasonably believed and apprehend the result the suit would not be gone against them. On the contrary, the suit ought to have been dismissed with exemplary cost. The situation was beyond the control of the petitioner, since in absence of the appellant defendant due to his ailments, there was none to look after the case on behalf of the defendant's appellants in the suit before the learned court, as it is the appellant defendant number 1, inasmuch as more conversant with the facts and circumstances of the case. The erstwhile learned advocate on behalf of the petitioners also dealt the case negligently, and in any event, inaction cannot be attributed to your petitioner. In the premises, it is incumbent to the end of justice delay in presentation of appeal be condoned, otherwise petitioner shall suffer either loss.
That means the knowledge of the decree when? In your case, when did you acquire knowledge of the decree?
Kindly see comes to
Para 12.
Yes.
Yes. So your challenge was the decree itself. You adduced evidence before the trial court.
I initially as DW1 adduced evidence, but it was not complete. But due to my medical conditions, I was restrained to hospital and home, which during that time I have requested my learned advocate to take appropriate steps. Although it was not taken and decree was passed.
Anyway, so you challenged the decree? So that is the question. When did you acquire knowledge as per this application? Which paragraph?
Kindly comes to paragraph 14. Page 71 portion.
Yes.
The decree was delivered on 7 lines from the below.
Below.
Top.
Top. Page 60.
71.
71. 71? Yes. Okay. 25/7/2009.
58, my lord, page,
Page?
59.
Page 59, yes.
The appellant defendant could not be represented, that paragraph onwards, if my lord kindly sees.
Yes, that is.
As a result, the appellant immediately contacted his present examiner with a certified copy of the judgment, and which was, however, delivered and so by the authorized advocate. The learned advocate was instructed to prefer appeal against the judgment and decree below on perusal of the papers. The aforesaid judgment and merely readily was prepared.
When it was prepared, 25/7?
Yes.
On the next day itself?
Yes.
Yes.
And then it was settled on next day, and then it was settled on 27th.
No, but the question is, after the appeal being drafted and prepared, it was filed.
Yes.
When did you come to know about the knowledge of the decree? Which paragraph?
That portion.
When was the decree passed?
A decree was passed. Decree was delivered on.
Passed, first of all, passed.
19/3/2008.
19/3?
2008.
Yes.
That is page 58.
Finally, judgment.
Page 58.
Top portion. Judgment was delivered on.
Came to learn from his advocate that no further step was taken. So when did you come to know about this?
It was, my lord, as per the.
You see, it was, the judgment was delivered on 19/3/2008. So this is your contention?
Yes.
And when did you come to know about the said decree? From your advocate or from the department or whatever it is?
It kindly comes to page 14.
Page
14, page 70. The allegation made.
Just a minute. Page 14.
Paragraph 14, page 70.
Paragraph 14, page. Paragraph 14.
Yes.
Page 60. Paragraph 14 of your application.
Accepted. Paragraph page 57, paragraph 11.
Page 57, paragraph 11.
Page 57. After being resumed to normal duties and activities, the appellant immediately contacted.
No, resume the duties.
Yes,
So
activity.
till which date you are ill? Which paragraph?
Just kindly sees.
So this is after you resume.
I contacted the learned advocate on.
Yes, which para that is?
11.
Para, yes.
Contacted his learned advocate and so at his chamber. And that day I received the information. And his utter surprise, he received the information the suit has been time decreed. So on 25th of July 2009, I have received the information that the suit was decreed.
(25/7).
Yes.
And 25/7 itself you directed the advocate to
Yes.
prepare memo of
Yes.
appeal.
No, immediately take steps, all steps, take steps on to present. Meantime, it was done. And on 27th, immediately.
Within 2 days. Yes, the decree was passed on which date?
2008.
2008.
No, which date? So, according to you,
19th
after 15/2, you did not have any contact with the advocate. So, when was the decree passed?
19th of March.
19th of March 2008. Page 58.
Page 58.
First paragraph itself. Finally, judgment was delivered on 19th of March 2008.
From whom did you come to know about this?
After resuming to normal
See,
activities,
from 2009. 2009, you contacted your advocate.
Yes.
That is after 1 year, 3 months.
Yes.
And you came to know this is your case.
Yes.
So, regarding your hospitalization, did you submit?
Yes, that was done.
Yes.
Kindly, if my lord kindly sees the judgment, it is page
Yes.
88.
You are the only plaintiff.
No, I am the defendant.
You are the only defendant.
No, no.
Then?
Since I was only looking after the case, there are other. No, no. Page 88, my lord. There are other two defendants also, but who are also solely defendants, ready person.
Page 88.
Yes.
Yes.
The reasoning of the learned court below while rejecting the delay.
Yes. No, you see how many days you are
490.
hospitalized. No, delay. How many days you are hospitalized? At all you are hospitalized?
Yes, I was hospitalized. Those documents were reduced before the appellate court also.
Hospitalized.
The learned appellate court, if my lord sees the judgment, learned appellate court did not say that those papers were not there. Learned appellate court was of the view that the doctor should have came and adduced evidence in support of those medical prescriptions.
Your medical documents were objected to by the other side?
But those were adduced evidence.
No. Your section 5 was contested.
Yes.
So did they dispute those medical documents?
Although they disputed, but kindly comes to page 88, my lord.
Yes, 88.
Of the paper book.
Yes.
If my lord sees the reasoning, the record is taken up for passing of the application under section 5 of the Limitation Act with section 151 of the Civil Procedure Code filed by the plaintiffs, appellant defendants. The main contention of the petition under section 5 of the Limitation Act, read with section 151 of the Civil Procedure Code, is that the respondent plaintiffs institute a suit for declaration, recovery of past possession, decree of mean profit along with other reliefs before the civil judge senior division at Alipur against the defendants, and same was treated as a title suit number so and so. After receiving the summons, the defendants appellant contested the same by filing written statement in the learned civil judge senior division. The appellant was looking after the suit. He adduced evidence on 2002, but his cross-examination could not be completed till so and so. Due to the petitions filed by the plaintiffs and on from so and so, the appellant was frequently admitted to hospitals.
Oh, that means it could not be completed till 2007.
Yes. Due to the petitions by the plaintiffs and on from 15th February 2008, the appellant number 1 was frequently admitted to the hospitals for his treatment. Although his advocate was instructed to take steps during his absence, after treatment, when he resumed his normal duties and he made contact with his learned advocate, he learned that since February 20.
So you see, the question is when your cross-examination was not complete. So the cross-examination, because due to the plaintiffs praying for time. So what happened to those cross-examinations?
Cross-examination could not complete. Thereafter, the learned advocate did not appear also in the proceeding, and the suit.
No, what happened with regard to that? Whether the other depositions were accepted or
no, nothing. That was not done.
That means the depositions of this DW1 all had to be expunged due to non-completion of the cross-examination.
That was done.
So, but
perhaps concluded. Or
yes,
perhaps concluded.
no, one sided.
Evidence was concluded.
No, you see, suppose the advocate does not conclude the cross examination, days after days, the court can declare it is concluded.
Yes.
But is it due to the fault of the advocate or due to the non-appearance of DW1?
Non-appearance.
The evidence has not been annexed with the paper book.
No, what is your instruction or what was before the learned court, learned appeal court? What was before the appeal court?
Detailed judgment.
Appeal court, may kindly seize my lord.
What is the, did they file any objection to this?
Oh, yes.
Yes,
ma'am.
section 5, they have filed objection.
So have you disclosed that?
Yes.
That
It's
is
there.
there. It's there in the
Yes,
paper.
which page it is?
May I?
It is in page 70.
May kindly seize page 63.
Page 63 onwards.
So what they have said regarding DW1?
Kindly, I am not taking from the. Kindly comes page 64, page 7.
Yes,
paragraph 7.
Yes.
The allegation made in paragraph 4 of the application are all untrue, motivated, perversive, and denied. The allegation that since the year 2003 was a ILZA would have it. The appellant defendant number became sick and from time to time was admitted to PRS Hospital and BK Roy Research Center with the complaint of chest discomfort and underwent various medical tests, which revealed that he was suffering from so and so. Besides, he was hypertensive, diabetic, and so and so, and he was under the constant treatment of supervision of so and so at PRS Hospital. As a matter of fact, he underwent coronary angioplasty, are all untrue and are denied. Your petition submits that appellant number 1, in order to fill up the lacuna of limitation, has invented the story of illness. Your petitioner further states that appellant could not produce a single scrap of paper of his illness issued by PRS Hospital and BK Roy Research Center. The story of his illness is totally imaginary. That the allegation made in paragraph 5 of the application are also so and so. As per the legal advice of his learned advocate, petitioner had to attend the court for recording of his deposition under great hardship up to 12/9/2007, and his cross-examination in the as DW1 in the suit was in progress are all untrue and denied. Your petitioner states that appellant number 1 possesses good physique and he is the president of a so and so and regularly used to participate in every state program of the said so and so, and as an active political worker of the said party regularly. That the allegation made in paragraph 6 of the application are all untrue, motivated, and perversive, and are denied. The allegation that is, in fact, despite of repeated requests, ventilating his ailments and constant medical advice, or not to take any constraints to stress or move outside the house, excepting any for emergency purpose. His cross-examination by the respondent could not be completed till so and so. In this situation, his cross-examination started on since so and so are all true and or untrue and are denied. And appellants are put to strict proof thereof. The allegation made in paragraph 7 7 of the application are all untrue, motivated, and perversive and are denied by your petitioner. The allegations that on a number of occasions during the deposition of the appellant defendant number 1 as DW1 in the suit before the learned trial court, further deposition was deferred at the instance of the plaintiff's respondent. Ultimately, on so and so, although attendance was filed on behalf of the appellant defendant in the suit, but DW1, namely appellant defendant number 1, could not turn up for his further cross-examination when the matter was brought up for hearing, as he fell sick in the court campus, are all untrue. Your petition states that every occasion during the course of hearing, appellant could not came before the learned court before 1 p.m. As a result, the court proceeding became seriously hampered. Respondent was harassed in every occasion, and the hearing of the suit was delayed. It is denied the depositions of appellant defendant number 1 in DW1 in the suit before the learned trial court was deferred the instance of the plaintiff respondent. The story of illness in the court campus of the appellant defendant is totally false, baseless, and the appellants are taken into strict proof thereof. The allegations made in paragraph 8 and 9 of the applications are all untrue, motivated, and perversive, and are denied by the respondents. Although he said learned advocate on record assured that he would take proper steps seeking adjournment on his behalf, considering his health condition, but it appears on record that nothing was done. Since Hajira was filed on, but DW1, namely the appellant here, could not turn up, his deposition was closed by the order of the learned trial judge, fixing so and so next day for further hearing. And on 15th February 2008, his ill health and in spite of medical advice restricting the movement of the appellant defendant, he visited the advocate of his in his court chamber, but he was informed by the advocate that since an adjournment period was filed on that date on so and so, the matter could not be taken up. It was adjourned, and next day could not be informed to the appellant defendant. At that moment, his advocate, when he assured him that he would inform the next day over phone, and thereafter learned advocate did not inform the appellant defendant about the next date of the suit. But whenever the appellant defendant on his own rang his learned advocate, he assured that he need not worry about the next date. But these are the repetitions of the
So what was the materials before the learned appellate court?
kindly comes to page 100.
Page
100.
Yes.
Second paragraph onwards. Now the main question that arises for my consideration is what was the compelling circumstances that delayed the appellants were filing the appeal in so and so days.
So the actual delay is 365. No, more than 1 year.
More than 1 year.
Yes. Near about 496 days.
May I place the third paragraph?
Yes.
The first plea that was taken by the appellant is that the appellant number 1 was seriously ill, that he could not attend the court from March 2008, and so he has no knowledge about the status of the suit in the lower court. But from the evidence of the appellant, I find the appellant stated that he was admitted to Piazzas Hospital in year 2003, and the exhibit 3 and 4 reveals the same. The appellant also stated in his that he had attended the court on so and so, but due to his illness, he could not adduce evidence.
No, exhibit 3 means these documents were exhibited.
Yes.
While that means before the trial court. This exhibit 3.
No, in the appellate court while reading the section 5 application.
So that is that you were hospitalized in 2003. It was exhibited on the petition being filed.
Yes.
Yes.
The appellant number 1 also stated that he last attended the court on so and so, but due to his illness, he could not adduce evidence, and next day was fixed on so and so. But since he could not attend the court due to severe illness. Let us see what documents placed by the appellants to prove the same. Exhibit 5 is a prescription without date. Exhibit 6 is a prescription on dated so and so. Exhibit 7 is series of 22 pathological reports dated 7th December 2005 to 23rd January 2008. So exhibit 8 are series of 4 pathological reports dated so and so. Exhibit 9 a series of 3 medical prescriptions so and so. Exhibit 10 a series of 11 pathological reports. Exhibit 11 is a prescription dated so and so. Exhibit 12 is discharge certificate issued by Ruby Hospital Limited dated so and so.
No, discharge certificate. In that particular certificate, the date of admission and the date of discharge was given.
Yes. Exhibit 13 is a medical report dated issued by Metropolis. Exhibit 14 is a 4 medical prescriptions so and so. Now I'll kindly seize, my lord, the author of those documents were not.
No, exhibit means proved.
Proved. The
That
authors of those documents were not produced before the court to produce their authenticity. It is duty of the appellant to bring the concerned doctor before the court, and tender the documents. It is not the case of the appellant that said doctors had expired, and it is a great hardship on the appellant to produce those doctors before the court. The court has taken a strong view here.
No, these were exhibited with objection. That is not there.
That is not there. May I proceed?
Anyway, you continue on the next day, 3 p.m. That is another fixed matter. Better you consider the decisions relied upon by the learned appellate court.
I have also brought 3 judgments, other judgments.
Whatever it is, the decisions relied by the learned appellate court, you give a compilation of those as well as the decisions you want to rely.
I will be humbly praying, if my lord kindly grants me leave to file an application on that issue, my lord, an additional substantial question of law.
So that you see that the court has power. I at present I don't think that is necessary. Another question is whether at the time of hearing condonation application, whether the court can go into the merit. That is another question of law.
But
you can consider this issue.
The jurisdiction point can be entertained.
Whatever it is, while considering the delay, that is considered condonation of delay by the appeal court, whether the court, while considering section 5, can consider the merits of the matter.
Since my lord is hearing a second appeal itself, although is a
No, it is on a limited point only. I cannot go anything. You try to find some decisions. I'll not go into that aspect at this stage regarding the jurisdiction of the court. You just see whether while considering section 5 application, court can consider the merits of the case.
Merit has not been considered by the appellate court.
Whether the court can, that is also another issue.
Yes, that is an issue, but that has not been done by the appellate.
The court may, if
First
the
appellate.
court thinks fit, the court may. Anyway, come with the authorities on that, and the decisions relied by the court. Yes, record an order. Learned advocate.
I will bring short date be fixed, my, so that the appeal be immediately.
Learned advocate.
Original appellant is already.
Our learned advocates, as the hearing could not be concluded, the matter be fixed on. আচ্ছা কবে আছে 4 তারিখে দুটোর সময়?
চার তারিখ না 7 তারিখ বলছেন।
4th
we have
4 তারিখে দুটোর সময় বৃহস্পতিবার এই মানে বৃহস্পতিবার
4th at 2 p.m. মালো।
আচ্ছা দুটোর সময়। Yes, 4/12/2025 at 2 p.m.
Like ওই বইটা আছে একটু দেখবেন একটু কোঅপারেটিভ অ্যাক্ট। হ্যাঁ কোঅপারেটিভ অ্যাক্টটা দিয়েছে।
তো দেখো
Appellant, my lord, Mr. Honorable Chatterjee.
The respondents number 14 to 20.
Yes, item number 35. 28.
3 p.m.
Right. Yes. You are for the appellant?
Appellant, my lord. Appellant, let me Mr. Chatterjee, Mr. Honorable Chatterjee, my lord. He's calling, my lord, I'm just starting it, my lord. May I place, my lord, first the appeals court judgment, my lord? Notice are detailed, my lord.
Yes, let
But
us
I am for
see.
the respondent.
No, let us see the grounds on which this appeal is to be heard out.
My lord. Kindly see, my lord, memorandum of appeal, my lord, that is at page 128 to 146 of the paper book.
Yes, 128.
The admission
Yes,
order.
Admission orders, my lord, you also will take, my lord. My lord, it would be, my lord, at page 147, my lord, this is the admission order, my lord, admission order. Whether the appellate court committed a substantial error of law
147.
in not holding, you will also got, my lord.
Hmm. Yes, whether the appellate court.
May I please, my lord?
Yes, second is whether there are many points of law.
Many points of law, whether the,
This is a concurrent finding of fact. I'll assist your lordship.
whether,
So,
my lord, the suit, my lord, for
Holding
declaring.
but on the
the
point
order
of
of
law,
attachment
it is very compact that.
before judgment passed.
No, no.
Yes.
My lord, I am late by
So there is a concurrent findings of fact. Anyway, there are 4 propositions of law on which this appeal has to be heard out.
but I am late by Mr. Chatterjee. My lord, late.
Yes, please.
Lord, Lordship will find, yes, there is a concurrent finding of fact, but
Yes, that I shall consider at the time of hearing.
certainly, my lord. Your
But on
Lordship
these
will
particular 4 points, it is to be heard out.
Yes, my lord. Now, before your Lordship looks into, my lord, the 4 points, your Lordship will find that the facts are very short. And I will not take much time of your Lordship with respect to fact, just giving your Lordship a background. That I was the owner of the property, there is no dispute. My lord, I had taken a loan.
You are the plaintiff. You are the plaintiff in the trial court.
Plaintiff, appellant in a suit for declaration of title and saying, my lord, an order, and also praying that the order which has been passed in, my lord, a money execution case numbers, well, I'll give you a lordship the second money execution case that has been obtained by way of fraud. This is, my lord, the suit, judgment of affirmance. Lord, I have prepared a list of dates as well for your lordship's kind consideration. তোমার দিয়েছে তো জানি তোমার কম্পাইলেশনের মধ্যে দিয়ে আছে এ ড্রপ করে দে দাদাকে একটু লিস্ট অফ ডেটসটা এ ড্রপ করে দে Lordship
150.
Yes, minute. 150 minute of
the paper book.
Yes, minute. Lord, your lordship takes up, Lord, the list of dates once. I guess, Lord, that should be, Lord, we've prepared like a bullet point for your lordship's consideration. It's like a bullet, not much.
Because as you know, second appeal, the scope is limited.
Very limited. That's why, my lord, I didn't want to, my lord, expand it. But I'm
Dispute
trying
of
to
1962.
Yes, my lord. What happens is a loan is taken, a loan is repaid. By exercising fraud on court, my lord, they've got the property sold, my lord, through an auction and obtained the property, my lord, in their own name. This is what it is. The entire, as we say in Bengali, my lord, Sharmarmo. This is the Sharmarmo of the matter. Loan was obtained, there was a suit, there was a degree, there was a compromise. In that compromise, my lord, about 950 rupees, my lord, is the compromise amount. Exact amount I'll tell you, lordship. That amount, my lord, was to be paid in 4 tranches. After the first tranche, my lord, we were unable to pay it. And then, my lord, what happened was they filed an execution case. In that execution case, my lord, was dismissed by
the borrower.
I was the borrower, but the owner of the property.
Yes.
Now, what happens is, in the first tranche, there was no problem. In the second tranche, my lord, I failed to pay. They filed, my lord, an execution case. That money execution case, my lord, of 1963 was, my lord, initiated, was the number 448 of 1963.
Suit of 1962.
62.
Execution case 1963.
63, that's the first execution case.
Yes.
That was, my lord, dismissed on part satisfaction with rupees 400. There, my lord, it was observed.
Satisfaction and part compromise.
Yes, my lord. No, compromise was early.
Okay.
Satisfaction happened there once because we had to pay it, my lord, in 4 tranches.
Anyway, that was disposed.
Absolutely. That was disposed. Before, my lord, we could understand, or before, my lord, the time limit passed for payment of the second or the third or the fourth tranche, they filed a second money execution case and got every order ex parte and auctioned it, my lord, sold the property to themselves. That is how, my lord, they became the owner, my lord, of the property. And this entire exercise is under challenge, my lord, in this suit. So today, my lord, they are getting a property worth about a few 100 crores, not 100, maybe, my lord, more than that, for 900 rupees. That too, after taking the money in terms of, my lord, the degree which was passed in the trial court. The money has been paid is an admitted fact. Maybe a little late, but that money, second money execution case of 1964 that your lordship has seen, that, my lord, was initiated for the balance of 362 rupees. That was, my lord, the amount which was left to be paid to them. This was filed ex parte saying that this is within the 2 years. So I don't have to give you notice.
The first one.
The second one.
Second one.
Second
yes.
one. First one I was there. I paid.
And that was disposed.
That was disposed of with part satisfaction.
Yes, but however it
Disposed
was
of. Yes, my lord. Then, my lord, they come with the second money execution. No service. Nothing.
Whether that first execution was suppressed?
I will show your lordship that it was. Wasn't suppressed to that effect. My lord, that we had paid them 400 rupees. That was not suppressed. But 362 rupees was the only amount which was required to be paid to them. And it was paid to them. There was a time limit within which I had to pay that. Before that time limit expired, they filed the second execution case and got these orders, my lord, in their favor ex parte. That is why we are saying, my lord, this is a fraud on court. And we come to know, my lord, way later in 1988. Way later, because they didn't proceed, my lord, after that, after getting, my lord, these orders. Once they started proceeding, my lord, that's when we came to know and we came to
possession of the property is
still with
you.
me. Still with me.
With the borrower.
With the borrower. Still with me. Possession never touched. During the pendency of the second appeal, my lord, they tried to, my lord, encroach, and what they did was they, my lord, broke the boundary wall. But possession till today, my lord, your lordship will see, is with me. There are, my lord, orders for local inspection. Everything is on record. I will show your lordship all of that. So this is really, my lord, the background of the matter. And now, my lord, may I kindly take your lordship, my lord, to the plaint ones. Lord, I have, it's a very voluminous compilation my learned senior friend has prepared. I wanted to.
No, this is the paper book.
Yes, my lord, there is a compilation.
No, this is not the paper book. Compilation.
There is a spiral binded compilation.
Where is that? Anyway.
Anyway,
this is the list of dates, I believe. This is the list of
dates. That's the list of dates, and this is, my lord, the documents, the plain, the written statement, and whichever is a little bit relevant for your lordship, my lord, that's I have taken out from here, and so that your lordship need not go through, my lord, the entire compilation.
This is because after all, to finally decide the matter.
Yes, my lord.
I have to go.
Your lordship will.
That will be easier for your lordship.
This one.
No, this paper book. It contains everything.
Now the compilation, I have a problem. Compilation, what has happened, since we have judges, my lord, from outside, we had to, my lord, translate it.
You have to translate.
Translate it. And that translation has created a problem.
But we
Now,
can
if you're
use the vernacular, not the
yes,
plain.
that's exactly why.
Translation is useful for all, not only the judges from outside. For every judges, it is very useful.
My lord, that is why I completely bow down to my learned senior and always do, my lord. But here, definitely, is that, my lord, the vernacular will be easier for your lordship, because in that compilation, what the mistake that has happened is from page number 3 and 4, my lord. It's not the plaint, it's, my lord, the deposition.
Anyway, I'm going through this one.
It's easier. And some of them, my lord, have also been omitted. So I did not want to waste your lordship's time. I requested my learned friend to, my lord,
এটা তো vernacular আছে
তোমার হাফ করে দিয়েছে দাদা, দেখো হাফ করে দিয়েছে। আর এইখানে তুমি যদি দেখো, এগুলো হচ্ছে তোমার এগুলো হচ্ছে তোমার
এই
কথাগুলো।
ওইভাবেই আছে বলে ওইভাবে
প্লেনটে ওরকম নেই,
ওখানে আছে
প্লেনটে নেই রে,
যেটা
প্লেনটে ওরকম ভাবে নেই।
amended plan আমার কাছে, হ্যাঁ amended plan এইটাই যেটা তুলে দিয়েছে, it is like that.
হ্যাঁ
Just rely on whatever
হ্যাঁ হ্যাঁ,
the
এক্স্যাক্টলি,
more
অ্যাবসলিউটলি,
on the contents than the
absolutely, একেবারে। Lord takes up the plate, Lord, I'll read with your lordship on this. Lord takes up paragraph 2.
Yes.
নালিশি জমি বাদীর খরিদা খাস সত্ত্বাধিকৃত জমি সম্পত্তি হইতেছে। কত ইংরেজি অ্যাক্ট সেটেলমেন্ট নালিশি জমি বাদীর নামে যথারীতি রেকর্ড হইয়াছে এবং ওই রেকর্ড অফ রাইটস যথারীতি ফাইনালি পাবলিশড হইয়া উহা স্থির ও বলবৎ আছে। প্রকাশ থাকে যে, মাই লর্ড কাইন্ডলি গট দ্যাট লর্ড, প্রকাশ থাকে যে বর্তমান WBLR অ্যাক্ট অনুযায়ী অনুষ্ঠিত সেটেলমেন্ট ও নালিশি জমি বাদীর নামে যথারীতি নালিশি মৌজায় 327 নম্বর খতিয়ানে রেকর্ড হইয়াছে এবং উহা অদ্যাপি অপরিবর্তিত আছে। নালিশি 902 নম্বর দাগের উপর বাদীর বসতবাড়ি বিদ্যমান আছে। কাইন্ডলি মার্কস দিস ইজ ওয়্যার আই স্টে, দিস ইজ ইম্পর্টেন্ট।
Page 3.
My lord, paragraph 2, this is what I am on. বাদী দেশ বিভাগের অব্যাহতি পরেই তৎকালীন পূর্ব পাকিস্তান অধুনা বাংলাদেশ হইতে ভারতে আসিয়া নালিশি জমি খরিদ করিয়াছিলেন এবং তৎপরে নালিশি 292 নম্বর দাগের জমির উপর, as I read, Milord, my learned senior friend makes a comment I thought when I was reading it as well. SIR and NRC, Milord, are in. Then every
This is also Bonga subdivision.
moreover, Milord, now every
In the history of 62.
absolutely, absolutely. And Milord, if this has to be SIR, then every Milord Bangal has to be. I don't know, Milord, your lordship, kindly do not take me amiss. Mr. Mukherjee isn't one. I am also, Milord, very much a Ghoti.
It's better not to disclose my identity. Although I may support some football club.
Football club. Your lordship doesn't mean that your lordship is
I may support that Mohun Bagan club, but I better not to disclose my identity.
Milord, Mr. Rai Chaudhary
Yes.
was actually from Bangladesh, but he was a very staunch Mohun Bagan supporter. Very staunch, Mr. Shyama Prashanna Rai Chaudhary. Mr. Dashgupta. Milord, those were very good old days, Milord. Mr. Dashgupta and Mr. Rai Chaudhary used to be, Milord, rivals. Mr. Dashgupta was very much a Kat Bangal, as we say, and Mr. Rai Chaudhary, Milord, was Mohun Bagan supporter. So every time there was a match, Milord, Bar Association room number 2 would be very, Milord, alive. We've forgotten all those days. When I first joined the profession, I was there, Milord, with them in that table.
It is probably 2000.
2001.
2001.
So I was there with them in that table and I witnessed that. And in the childhood also, Milord, I would obviously, Milord, go through all those rivalry and all that, but saw that on hand, Milord, in this, in Bar Association room number 2. Nowadays, Milord, it's used for political meetings and things like that. Earlier, Milord, it wasn't like that. Even when we joined the profession, it wasn't like that.
25 years ago or something.
Yes, it was very different from what it is now. Of course, my lord would know that. Then, বাদী দেশ বিভাগের অব্যাহতি পরেই তৎকালীন পূর্ব পাকিস্তান অধুনা বাংলাদেশ হইতে ভারতে আসিয়া নালিশি জমি খরিদ করিয়াছিলেন। অর্থাৎ নালিশি 902 নম্বর দাগের জমির উপর বসত গৃহাদি নির্মাণ করিয়া তদ্বদি উক্ত বসত বাটিতে সপরিবারে বসবাস করিয়া আসিতেছে। Till today, my lord, we are in possession of that, my lord, house of ours. বাদী নালিশি 902 নম্বর দাগের উপরিস্থিত তাহার উক্ত বসতবাটির সহিত নালিশি সাসেনসাজ এবং দাগের জমি ইনকম্প্যাক্ট করিয়া দখল করিতেছেন। 902 নম্বর দাগের জমি ব্যতীত উপরোক্ত দাগগুলির উপর বাদীর কোটিয়ার তথা কার্টিলেজেস বিদ্যমান আছে। ওই সকল দাগগুলির উপর বাদীর উপজাত বহু আম গাছ, কাঁঠাল গাছ, নারকেল গাছ, সুপারি গাছ ইত্যাদি নানাবিধ ফলপ্রসূ বৃক্ষাদি বিদ্যমান আছে। বাদী তাহার উপরোক্ত বসত বাটিতে সপরিবারে বসবাস করিয়া আসিতেছেন এবং ওই সকল ফলপ্রসূ বৃক্ষাদি ফলাদি ও উপসত্তাদি গ্রহণ করিয়া আসিতেছেন। নালিশি জমির উপর বাদীরই খননকৃত একটি পুষ্করিণী বিদ্যমান আছেন। বাদী উহাতে মৎস্য ছাড়িয়া উহা সংরক্ষণ ও গ্রহণ করিয়া আসিতেছেন। নালিশি জমির উপর বাদীর একটি বিদ্যুৎ চালিত শ্যালো টিউবওয়েল বিদ্যমান আছে। উক্ত শ্যালো টিউবওয়েল এর সাহায্যে জল উঠাইয়া বাদী নালিশি 888 নম্বর দাগ ভিন্ন ওপর নালিশি পাঁচটি দাগের জমিতে চাষযোগ্য স্থানে জল করিয়া ফসলাদি উৎপাদন ও গ্রহণ করিয়া থাকেন। প্রকাশ থাকে যে নালিশি 888 নম্বর দাগের জমি বাদীর বসত বাটি হইতে কয়েকটি দাগের ব্যবধানে অবস্থিত হওয়া বাদী ওই দাগটিতে তাহার উক্ত শ্যালো টিউবওয়েল হইতে জল লইতে পারেন না এবং সে কারণ ওই 888 নম্বর দাগের জমিতে স্বাভাবিকভাবেই বৈশাখ মাসে বর্ষা হইলেই উহাতে ধান পাট রোপণ করিয়া উহা সংরক্ষণ ও গ্রহণ করিয়া থাকেন। উক্ত 888 নম্বর দাগের জমি ব্যতীত উপরোক্ত অপর 5টি দাগ পরস্পর সংলগ্ন হওয়ায় এবং বসতবাটির সহিত একট থাকায় ওই সকল দাগগুলির যথেষ্ট পরিমাণ ফাঁকা চাষযোগ্য স্থান বাদী পূর্বোক্ত রূপে চাষ বাদে ফসলাদি উৎপাদন ও গ্রহণ করিয়া থাকেন। প্রকাশ থাকে যে বর্তমান ওই 5টি দাগের জমিতে কতক অংশ বাদীর উপজাত বোরা চাইনিজ ধান্য বিদ্যমান আছে এবং উহা সুপক হইয়া কাটবার উপযোগী হইয়াছে এবং বাদী উহা কাটিয়া লইতেছেন। এত দাবি উচিত বাদীর বসত বাটির এলাকার মধ্যে বাদী একটি মুরগির পোল্ট্রি স্থাপন করিয়াছেন। বাদী নালিশি জমি সম্পত্তি বাবদ মালিক পশ্চিমবঙ্গ সরকার সেরেস্তায় করাদি আদায় দিয়া দাখিলা গ্রহণ করিয়া আসিতে। We are paying them, my lord. Now this is important. Paragraph 3, my lord, starts the cause of action of this suit. বহুকাল পূর্বে বিবাদীগণের পূর্ববর্তী অধুনা মৃত রামচন্দ্র মুখোপাধ্যায় মহাশয় নিকট বাদী কিছু টাকা ঋণী ছিলেন। অ্যাডমিশন অফ ডেট। উক্ত মৃত রামচন্দ্র মুখোপাধ্যায় মহাশয় ওই টাকা আদায় পাইবার জন্য অত্র আদালতে বাদীর বিরুদ্ধে সাচ এন্ড সাচ মানি মামলা মোকদ্দমা দায়ের করিয়াছিলেন। উক্ত মৃত রামচন্দ্র মুখোপাধ্যায় মহাশয় নিজে এবং তৎপক্ষে তার পুত্র 1 নম্বর বিবাদী বাদীর নিকট হইতে পাওনা টাকা নগদে বুঝিয়া পাইয়া তাহারা উক্ত মামলা মোকদ্দমা ছাড়িয়া দিয়াছিলেন। There was a compromise, your lordship remembers, I told your lordship.
See, the original plaintiff of this suit was a party there.
Yes, my lord.
Now it is the substituted.
I bow down.
But what you are now proceeding, there's the substituted.
Absolutely.
But this 88, that is the original plaintiff there.
My lord. And even the defendants part, they were the originals then.
Both were original
Yes,
plaintiff and defendant.
Yes, Boniade, such and such money execution, this is important. 1963 number money execution case, Aposh Mimangsha Sutre, on part satisfaction dismissed hoiya jay. Ek nalishi jomi, ক্রোকাবদ্ধ থাকে না, ক্রোক করা বলে না, এবং ডিক্রির বকরি টাকা বাদী রামচন্দ্র মুখোপাধ্যায়ের মৃত্যুর পর 1 নম্বর বিবাদীর দাবি ও তলব তাগাদ মতে সুদস্থ 950 টাকা 1 নম্বর বিবাদীকে পরবর্তীকালে পরিশোধ করিয়াছেন। This is important. Below the ঋণ was 950, the debt was 950. This 950 was paid to them. They've taken the money. Below, even if your lordship looks into from a very on the ground of equity, forgets about rights and not anything else. They were entitled to 950 rupees.
This is an admitted position.
This is an admitted
The
position.
written
It
statement.
is an admitted position by documents. And even in written statement, at one point of time, though they will not directly admit that, but this is an admitted position that they've taken money and the documents are all on record. So what I am trying to impress upon your lordship and what the trial courts did not, my lord, consider was, even if your lordship looks by equity, law is one side, but law, my lord, takes towards equity. He was entitled to 950 rupees. He's got the 950 rupees. He was not entitled to anything more. So today, so this was what, my lord, I feel, my lord, the honorable, the learned judges in the court below ought to have looked into that from this angle as well. Then Bibadi Parabortikale, this is basically, my lord, unjust enrichment of a different kind altogether. 950 rupees, my lord, the entire property they say is theirs, and that too from a deal, from an order where I was not made a party at all.
Okay, all these things will be considered, but the thing is this, as you know, I have to confine myself with regard to this 4.
Absolutely, my lord, and it's a part of that. This entire thing is a part of
I have to confine myself.
Absolutely, I will not go beyond that. I will not go beyond that. This is all a part of those 4, my lord, substantial questions of law which has been framed. Your lordship cannot go beyond it at all. Then, of course, your lordship may always frame one more, but your lordship cannot go beyond the substantial questions of law at all. Then, আমতে উক্ত ডিগ্রি কৃত সমুদায় টাকা সুদ সহ পরিশোধ হইয়া যাওয়ায় ওই ডিগ্রি এবং এক্সিকিউশনের কোনো অস্তিত্ব ছিল না বা নাই। This is the সারমর্ম, my lord, of my plain case. This is summarizes, my lord, my plain case basically. Then 1 নম্বর বিবাদী সম্প্রতি প্রকাশ ও প্রচার করিতে আরম্ভ করিয়াছেন যে তাহার পিতা বাদীর বিরুদ্ধে এক অত্র আদালতের সাচ মানি মোকদ্দমায় ডিগ্রি প্রাপ্ত হইয়াছিলেন এবং ওই তথাকথিত ডিগ্রি সাচ নম্বর মানি জারি দিয়া তিনি নাকি নালিশি জমি ক্রোক নিলাম সরাইয়া ওই নিলাম 365 টাকা মূল্যে খরিদ করিয়াছিলেন এবং তিনি নাকি ওই তথাকথিত নিলাম খরিদ্দ সম্পত্তিতে অর্থাৎ নালিশি জমি সম্পত্তি আদালত যোগে বয়নানামা জারি করিয়া দখল লইয়াছিলেন। বিবাদী পক্ষের কথিত উক্ত সাচ দিস ইজ দ্য সেকেন্ড, my lord, মানি এক্সিকিউশন কেস, মানি জারি প্রসিডিংসে নালিশি জমি পুনরায় ক্রোক দেওয়া হয় নাই এবং ক্রোক বদ্ধ না হইলে কোনো সম্পত্তি নিলামে বিক্রয় হইতে পারে না। Just see one second. My lord, your lordship was asking.
Again, proceedings was ex parte.
And the courts have held that since, my lord, it's within the 2 years of the date of the degree, so no
The second proceedings.
But when you are putting it up on sale, I'll show your lordship, my lord, from the civil procedure code. When you're putting it up on sale, then notice has to be given. And sees, my lord, the malafide here, he is putting it up on sale, he is buying it. It's not somebody else who's bought it. He has put it up on sale.
Third party right has not accrued.
No, he has. He has taken it. And my lord, something which is not attached, that's my plain case. And I'll try and demonstrate that before your lordship as well. If it is not attached, then there was no question of putting the property on sale. বিনা ক্রোকে কোনো সম্পত্তি নিলামে বিক্রয় হইলে ওই বিক্রয় শর্মাবস্থায় বেআইনি, ভয়েড ও অকার্যকর হইবে এবং তদ্বারা দায়ীকে স্বত্বাধিকার বিন্দুমাত্র কোনো ক্ষুণ্ণ হইবে না। এমতে নালিশি জমি ঐরূপ বিনা ক্রোকে এবং বিনা নোটিশে নিলামে বিক্রয় বা অকশন সেল হইলে উহা বেআইনি, অকার্যকর এবং ভয়েড হইতেছে। তদ্বারা নালিশি জমিতে বাদীর সত্ত্বাধিকার বিন্দুমাত্র ক্ষুণ্ণ হয় নাই। তদুপরি উপরোক্ত such and such মানি জারি ডিসমিস হইবার পর উক্ত রামচন্দ্র মুখোপাধ্যায় পুনরায় such and such মানি জারি দাখিল করিবার কোনো অধিকার ছিল না। আইনি ও অধিকার বহির্ভূত হওয়ায় ওই such and such the second execution case মানি জারি সম্পূর্ণ বেআইনি, অকার্যকর ও void proceeding ছিল এবং উহাতে নালিশি জমি কোনো ক্রমে নিলামে বিক্রয় হইতে পারে না এবং ডিক্রিদারের ওই রূপে নালিশি জমি নিলামে খরিদ করিবার কোনো অধিকার ছিল না। রামচন্দ্র মুখোপাধ্যায়ের ওই নিলাম খরিদ সম্পূর্ণ বেআইনি, অকার্যকর এবং ভয়েড হইতেছে এবং তার দ্বারা রামচন্দ্র মুখোপাধ্যায় বা 1 নম্বর বিবাদী নালিশি জমিতে কোনো সত্ত্বাধিকার বা দখল প্রাপ্ত হয়েন নাই। উক্তরূপে বিবাদীগণের তথাকথিত বয়নানামা ইত্যাদি যাবতীয় কাগজপত্র সম্পূর্ণ মিথ্যা, বেআইনি এবং ভয়েড হইতেছে। বাদী এ যাবৎ কাল উক্ত such and such মানি জারির বিষয় অবগত না থাকায় এবং ওই প্রসিডিং সম্পূর্ণ বেআইনি থাকায় তামাদি রক্ষিত হইতেছে। 1 নম্বর বিবাদী বাদীর অজ্ঞাতে ভিসন্ধি মূলে ওই সকল বেআইনি কার্য করিয়াছেন। 3 নম্বর বিবাদী কোনো ক্রমে নালিশি জমিতে কোনো সত্ত্বাধিকার প্রাপ্ত হয় নাই। তামাদি আইনের বিধান অনুযায়ী বিবাদীগণের নালিশি জমি বাবদ কথিত যাবতীয় অধিকার দীর্ঘকাল পূর্বে নির্বাসিত হইয়া গিয়াছে এবং বাদী নিজ সত্ত্বাধিকারে স্ট্যাটিউটরি রাইট বাই অ্যাডভার্স পজেশন মূলে নালিশি জমি খাস সত্ত্বাধিকারের দখল ভোগ করিতেছেন। বিবাদীগণ কোনো নালিশি জমি দখল করেন নাই। অপরদিকে 3 নম্বর বিবাদী প্রচার ও প্রকাশ করিতেছেন যে তিনি নাকি 1 ও 2 নম্বর বিবাদীগণের নিকট হইতে নালিশি জমি সম্পত্তি সম্পর্কে একটি বয়নানামা হাসিল করিয়া লইয়াছেন এবং সে কারণে তিনি 1 নম্বর বিবাদীর সহযোগে নালিশি জমি সম্পত্তি তথা বাদীর বসতবাটি জোরপূর্বক দখল করিয়া লইবেন। বস্তুত পক্ষে এই প্রকার কোনো ডিগ্রি জারি বা নিলামের বিষয় বাদী কিছুমাত্র অবগত ছিলেন না বা ওই সম্পর্কে কোনো নোটিশ বা পরোয়ানা আদি বাদীর উপর কদাপি কখনো জারি হয় নাই। ওই প্রকার কোনো ডিগ্রি জারি এবং তন্মূলে নালিশি সম্পত্তি কোনো প্রকার ক্রোক নিলাম অকশন হইয়া থাকিলে ধূর্ত 1 নম্বর বিবাদী এবং তাহার পিতা মৃত রামচন্দ্র মুখোপাধ্যায় মহাশয় আদালতের প্রসেস সার্ভারকে অবৈধ উপায়ে বর্ষীভূত করিয়া ওই ডিগ্রি জারি বা নিলাম সম্পর্কিত সমস্ত নোটিশ বা পরোয়ানাদি মূল্য গোপন করিয়া ওই নোটিশ বা পরোয়ানাদি জারি সম্পর্ক মিথ্যা রিটার্ন ও রিপোর্ট
Before the executing court, it was recorded. The decree executed and
my lord,
possession handed over.
My lord.
So before the executing court.
Exactly. Which was, beloved, we say, beloved, it's false because we are still today we are in possession. জারি হওয়া দৃষ্ট হইলে তাহা আদালতের প্রসেস সার্ভারের সহিত যোগাযোগ নিজ বাধ্য অনুগত মোকাবেলা ও এটা কি নাম ধূর্ণির নাম নিমাইয়া বা সহি লইয়া কাগজে কলমে দখলি পরোয়ানা জারির কার্য হাসিল করিয়া রাখিতে পারেন। We said that they might have recorded that which fell from your lordship. Just now which fell from your lordship. That was the plate case itself. Then নালিশি জমি বনগ্রাম শহর হইতে 5 মাইল দূরে যশোহর রোডের পাশে অবস্থিত। উহার মূল্য 20 বৎসর পূর্বে ও প্রীতি বিভাগ 10,000 টাকার কম ছিল না। মাত্র 365 টাকায় নালিশি 6 বিঘা জমি এবং তত্ত্বে টিন ও টালি সমলিত ইটের 5 ইঞ্চি দেয়াল বিশিষ্ট মূল্যবান গৃহাদি সম্পত্তি কেমন করিয়া নিলাম বিক্রয় হইতে পারে, উহা কল্পনার অতীত এবং শকিং টু হিউম্যান কনসিয়েন্স বটে। বসতবাটি নিলামে বিক্রয় করিবার আদালতের কোনো জুরিসডিকশন নাই। নালিশি জমি সম্পর্কে ওই প্রকার কোনো নিলাম বিক্রয় হইয়া থাকিলে উহা সম্পূর্ণরূপে বেআইনি, ভুয়া, তঞ্চকি, ফুল অ্যান্ড নাল অ্যান্ড ভয়েড এবং উইদাউট জুরিসডিকশন হইতেছে। উহার দ্বারা নালিশি জমি জমা সম্পত্তি বাদীর আর্জি বর্ধিত স্বত্বাধিকার বিন্দুমাত্র হয় নাই এবং আইনত হইতে পারে না। যা হোক, বিবাদীগণের উপরোক্ত রূপে অবৈধ ও অন্যায় কার্যে কলাপে এবং অস্ফালন ও নালিশি জমি ও বসতগৃহাদি সম্পত্তিতে বাদীর শান্তিপূর্ণ সত্ত্বদখল মেঘাচ্ছন্ন হওয়ায় বাদী উহার স্থির সত্ত্ব ও স্বার্থ রক্ষার্থে এই মতে অত্র মোকদ্দমায় দাখিল করিতেছেন। এত্র মোকদ্দমায় প্রার্থিত প্রতিকার পাইতে বাদী আইনত ও ন্যায়ত অধিকার হইতেছেন। Basically, if your lordship sees, if I owe him 365 rupees, the court, even if they were entitled to get the auction done, the court had to find out the valuation of the property. After the valuation of the property, my lord, was finalized, the court would have given them, my lord, the amount, sold the money in auction, given them the amount which they want, and the rest of the money should have come to
After
me.
fixing the reserve price.
Absolutely. Nothing, my lord, I will show your lordship, nothing was done at all. So for a 365 rupees debt, which was eventually, my lord, paid off to them, which they have, my lord, acknowledged later, this property, my lord, went off, my lord, in auction and sold off, my lord, in a very, very, my lord, in my respectful submission, absolutely fraud was involved here. It could not have been, my lord, that a sale is conducted without service of notice on the other side. Could not have been.
Sale and the price is.
Exactly.
No.
No reserve price.
No, the price is, it is an admitted that entire amount is paid, that 950.
It is. I'll show your lordship that. I'll show your lordship that. From the written statement and the documents, my lord, involved, my lord, in the proceeding. I'll just finish off. This was the amended part. প্রকাশ থাকে যে অত্র মোকদ্দমার মূল বাদী ধীরেন্দ্রনাথ বৈদ্য মহাশয় তাহার জীবদ্দশায় অত্র মোকদ্দমা চলাকালীন ইংরেজি সাচেন্সাস তারিখে নালিশি সম্পত্তির তাহার যাবতীয় স্থাবর অস্থাবর সম্পত্তি সম্পর্কে তাহার স্ত্রী বর্তমান 1 নম্বর বাদী শ্রীমতী কুমুদিনী বৈদ্য বরাবর একখানি উইল সম্পাদন করিয়া যান। উক্ত উইলখানির প্রবেট পাইবার নিয়মিত বর্তমান 1 নম্বর বাদী বনগাঁ মাননীয় ডিস্ট্রিক্ট ডেলিগেট আদালতে মিসকে সাসেন্সাস মোকদ্দমায় দাখিল করেন। উক্ত মোকদ্দমা দায়ে দরখাস্তকারী কুমুদিনী বৈদ্য মহাশয় উইল প্রবেটের প্রার্থনায় মঞ্জুর হয় এবং গত ইংরেজি বিল, this is not something which is very important. Probate of the will wouldn't give me title. It is just below that the will was correct. I'm not troubling your lordship.
Who executed that will? It was
my predecessor.
Your predecessor.
My husband. 16 আনা সত্ত্ব দখল বর্তমানে 1 নম্বর বিবাদী নালিশি জমি সম্পত্তিতে অ্যাবসলিউট ওনার হিসেবে শান্তিপূর্ণ সত্ত্ব দখল পরিচালনা করিয়া আসিতেছেন। Then the prayers your lordship will find at page just later. উপরোক্ত অবস্থা মতে বাদী প্রার্থনা করেন যে আর্জি তফসিল বর্ণিত নালিশি জমি সম্পত্তিতে বাদীর আর্জি বর্ণিত সত্য সাব্যস্ত ও প্রচার করিতে আজ্ঞা হয়। বাদীর আর্জি বর্ণিত অত্র আদালতে সাচেন্সাজ নাম্বার মানি জারির দরখাস্ত প্রসিডিংস এবং ওই জারি বনিয়াদে নালিশি জমি নিলামে বিক্রয় উহার সাচেন্সাজ এবং তথাকথিত দখল প্রদান ইত্যাদি যাবতীয় কার্যাদি বেআইনি অকার্যকর উইদাউট জুরিসডিকশন নাল অ্যান্ড ভয়েড সাব্যস্ত ডিগ্রি হয়। নালিশি জমি সম্পত্তি বাদীর আর্জির বর্ণিত শান্তিপূর্ণ দখল বিবাদীগণে যাহাতে কোনো প্রকার বাধা permanent injunction. Then my lord kindly looks to the written statement.
Yes.
Compilation কোথায়? Compilation. না না আমার এটাতে
By defendant number 3.
Yes, my lord. Have a look at page 19 first. আমাদেরটা কিসের আছে? The smaller compilation you're also looking at, that's at page 12.
Page 9. Smaller compilation.
Yes, my lord, that's
Page
at
12.
12.
Yes, this is the written statement.
My lord, that's the written statement. There are two written statements, my lord. This one is by defendant number 3. And the other one, my lord, number 1 and 2. One and 3 at 5.
1, 3, and 5. No, this is by 3.
Yes, my lord. The one is at page 17. 1-7.
Page 17, yes.
This one is by 1. 1, my lord, is the son of the
Original
Mukhopadhyay, that
Mukhopadhyay.
original, the person.
The original
that decree holder.
My lord, kindly have a look at paragraph. No, the first 3 or 4 paragraphs are the usual paragraphs. Lordship need not trouble my lord self. Looks to my lord paragraph 6. 1 নম্বর বিবাদী এই মোকদ্দমার অনাবশ্যক পক্ষ নালিশি হইতে তাহার কোনো সত্য সাব্যস্ত বা দখল নাই, সে কারণে তৎপরিতে এই মোকদ্দমা চলে না। মিসজয়েন্ডার অফ পার্টিজ দোষে বাদীর মোকদ্দমা চলে না। বাদীর আর্জির 2, 3, 4, 5 দফার উক্ত মিথ্যা ও তঞ্চকি নালিশি জমি বাদীর পাশে গত WBLR অনুযায়ী রেকর্ড হওয়া বাদী বাংলা দেশ হইতে আদেশে আসলে
বাংলাদেশ হইতে
এদেশে আসা এবং নালিশি কি বলে
নালিশি
জমি খরিদ করা বা নালিশি 902 দাগের উপরোক্ত it's a denial of whatever I've said in my plain period with respect to paragraph 3 that had come.
That is the simply denial.
Simple denial. My lord, your lordship sees the one which might get a little bit of importance is a little later. But just for the sake of Proban Thake J, if your lordship has got.
Yes, Proban Thake J.
5টি দাগের লর্ডশিপ got it, blood?
Yes, 5টি দাগের
প্রমাণ থাকে যে 5টি দাগের জমির কতক কতক অংশে বাদীর কি এটা বসবত চাই, কিন্তু ধার্য থাকার উক্তি ও বসতবাটির এলাকার মধ্যে বাদী একটি মুরগির মেলড again টাকা পয়সা লইয়া তাহাদের দাখিলি মোকদ্দমা দেওয়া সহযোগিতা হয়ে গেছে। তারপরে if your lordship turns over, my lord.
Yes.
এটা কত কি করে আরজির 4 দফার এটা ইজ মোর কোথায় গেল নম্বর পাতায় পরে উহা 2 নম্বর কাগজের নিকট। Just give me a second, just a second. That's as usual. Lord, I was trying to find out if your lordship sees the first লাইন আরজির 4 দফার উক্ত সত্য বটে বাদী দখিত জমি মানি লেন্ডার্স, if I am not mistaken, my lord, this is money lenders এর মোকদ্দমার দিনে 365
This page
টাকা।
17.
Yes, my lord. 18.
18.
First page. First line.
Yes. Money lender.
Yeah,
Decree jari dia.
my lord. 4 দফার উক্ত অংশ বিদ্য সত্য বটে বাদী দখিত জমি মানি, এটা কি ল্যান্ডার্স দিকে না সেন্ডার্স দিকে চলো? মানে মানি ল্যান্ডার্স এর কথা কিন্তু কোথাও হয়নি, সেই জন্য আমি একটু অবাক হচ্ছি। May I once look into
Money
the-
lender probably.
Yes, can I
Money
once
lender er mokoddamar. How can it be money sender?
Yes. May I once
Money
look into
lender
the money lender এর মোকদ্দমার
Yes.
ডিগ্রি?
My
দিয়া
money
300
মানে suit filed by money lender.
Yes, can I once look into the original ones? It will be easier for me to find.
Go through the রেকর্ডটা দেখান।
রেকর্ডটা একবার
টাইপ করা আছে,
টাইপ করেছে 7 নম্বরটা দেখ। Yes, Miller, I've got it. আরজির 4 দফার উক্তি আংশিক সত্য বটে বাদী কথিত জমি মানি লেন্ডার মোকদ্দমার ডিগ্রি জারি দিয়া 356.65 টাকা নিলামে খরিদ করিয়া বায়নানামা জারি ক্রমে দখল লইয়াছিলেন সত্য। We had not said, my lord, that they had taken possession. We had said, my lord, that they had, my lord, this 365, I was indebted to them. But that they have taken possession, we had never said so. Lordship remembers the plaint. Never have we said that ever they had taken possession.
Rather, you have challenged that.
Bow down.
That they have anyway recorded it as decree executed.
Bow down. পরে উহা 2 নম্বর বিবাদীর নিকট বিক্রয় করিয়া দখল দিয়েছেন সত্য। উক্ত জারির মোকদ্দমায় নোটিশ সেল প্রক্লামেশন যথারীতি আদালতের যোগে জারি হইয়াছিল এবং 1 নম্বর বিবাদী সরজমিন দখলপ্রাপ্ত হইয়াছিলেন। এই রিপোর্ট মধ্য কোনরূপ তঞ্চকতা ছিল না। নালিশি জমিতে বাদীর আদৌ কোনো দখল নাই। So, my lord, this is what their submission is before your lordship or in the suit, that they have the entire possession, we have got no possession. This is what the written statement is. Then, প্রকৃত বৃত্তান্ত এই যে, this is important, this is their part of the story. এই বিবাদীর পিতা মৃত রামচন্দ্র মুখোপাধ্যায় অত্র আদালতের, এটা কত নম্বর পেজে আছে? এটা কিসে আছে? কম্পাইলেশন? Yes. এই বিবাদীর পিতা মৃত রামচন্দ্র মুখোপাধ্যায় অত্র আদালতের 1962 সালের 59 নম্বর মানি মোকদ্দমায় ডিগ্রি প্রাপ্ত হইয়া উহা 1964 সালের মার্কস দিস 1964 সালের 63 নম্বর মানি জারি দিয়া আদালতের যাবতীয় যথারীতি জারি করিয়া গত ইংরাজি সাচেন্সাস তারিখে নালিশি জমিতে যথারীতি দখলপ্রাপ্ত হন এবং গভর্নমেন্টের খাজনাদি দিয়া দাখিলা প্রাপ্ত হন। প্রকাশ থাকে
record of rights.
Yes, ma'am. And we'll show the record of rights to your lordship. হয়। প্রকাশ থাকে যে পূর্বোক্ত মানি মোকদ্দমা মানি জারিতে বাদী বিবাদী থাকেন। উপরোক্ত মানি মোকদ্দমা ও মানি জারি এই মোকদ্দমা বাদীর বিরুদ্ধেই পরিচালিত হয়। বাদী তাহা পূর্বাপর সমস্ত বিষয়ে অবগত ছিলেন ও আছেন, তৎসত্ত্বেও নিতান্ত দুর্লভের বশবৎ হইয়া এই মিথ্যা মোকদ্দমা করিয়াছেন। পক্ষান্তরে এই বিবাদী নালিশি জমি খরিদের পরে দখল লইয়া কিছুকাল দখল করিয়া ৩,৫০০ টাকা পণ গ্রহণে কালপুর গ্রাম নিবাসী সুধীর কুমার সরকারের নিকট নালিশি ৭ শতক জমি বিক্রয় করিয়া তাহার নালিশি জমিতে দখল দিয়াছেন। তিনি উক্ত জমি জমা যথারীতি দখলকার আছেন। তিনি প্রকৃতপক্ষে বিবাদী হওয়ার উপযুক্ত বটে। তৎসত্ত্বে এই নিঃসত্ত্ব বিবাদীকে অন্যায় মতে করিয়াছেন। বাদী এই মোকদ্দমায় কোনো প্রতিকার পাইতে পারেন না। পক্ষান্তরে এই বিবাদী দেওয়ানি কার্যবিধি আইনের ৩৫ ধারা বিধান মতে এক্সেম্পলারি কস্ট হইতে অধিকার হইতে এবং তাহা তিনি দাবি করেন। বাদীর মিথ্যা ও হয়রানকার মোকদ্দমা ডিসমিস হইবে ও এই বিবাদী এক্সেম্পলারি কস্ট পাইবেন। প্রকাশ থাকে যে বাদী এই বিবাদীর পিতার ও বিবাদীর নিকট নালিশি বসতবাটির জমিতে সাময়িকভাবে বসবাস করিবার জন্য বহু কান্নাকাটি করায় তাহারা ওই জমিতে অনুমতি সূত্রে বসবাস করিতে দিয়াছিলেন। Marks this. So my possession as of today is admitted. They have tried to
So
create a
they
story.
are mentioning about a third party.
Yes, they are mentioning about the third
party is right.
Yes, and they are saying that I was allowed to stay in the premises as a licensee. They are admitting, Willard.
Licensee means licensee by the third party or
No,
by them?
they are saying they have given.
But on the other hand,
On the hand, they have sold
third
it.
party's mention is there, mention of third party.
And they are saying
Which
that they have
according to
given
you,
them possession.
No, which according to you, third party right has not accrued.
Nothing. Cannot. Because if the right which has not come to them cannot, they cannot sell. Today, if I sell the High Court, to whoever I sell, his rights do not get crystallized. He can't become the owner of the High Court. উপরোক্ত সমস্ত অবস্থা মতে বাদীর উক্ত অন্যায় অবৈধ জারির মোকদ্দমায় ডিসমিস করত এই বিবাদী খরচা দিতে আজ্ঞা হয়। That's what his plaint is. Then 3 নম্বর বিবাদী, my lord, your lordship will find that a little later. যাকে বিক্রি করেছিল। Now, 3 নম্বর, my lord, is the one whom they say, my lord, they have sold the property to. That is Sudhir Kumar Kormokar, if I am not mistaken.
No, item 3 is the third party.
Yes, my lord. Subject to correction, my lord, by my learned senior friend.
Is the third party.
Is the
Defendant
third
number 3 is
party
the
to
third
him.
party.
Yes, my lord. And to him, my lord, this was sold and this is his.
Defendant number 3 purchased in 1988.
That's when we, my lord, came to know.
That means you see, auction took place in 64.
Yes.
So Mr. Mukherjee's client purchased it in 1988.
88.
That means if auction has taken place in 1964.
64.
And the in auction purchase, it was purchased by the
Decree holder. His predecessor, yes.
No, by the decree holder.
My lord.
And
That
thereafter,
decree holder.
Mr. Mukherjee's client purchased in 1988.
That's when we come to know, my lord, when Mr. Mukherjee's client tried to disturb our possession. That's when we come to know and we file this suit. Now, may I continue on the next occasion?
Anyway, you can continue.
Whenever your lordship pleases, my lord.
Okay. Kindly give a date and time, brother, we can.
Whenever.
Yes, record and order. Learned advocates, learned counsels for the parties are present, heard learned counsels. As the hearing could not be concluded, let this matter appear on. এই 4 তারিখে কি দুটোর সময় দেওয়া আছে?
Better, my lord, at 2 o'clock.
2 o'clock will be, yes, because there might be spate of 3:30s coming.
Okay, when is your other matter fixed?
But that is on 7th.
7th at 2 or 3?
That is at 2 o'clock.
So on 7th, shall I keep it?
Lordship keeps it at 2 o'clock any day, my lord, not at.
No, in that case, I have to keep it at 3.
On 6th at 2.
আচ্ছা 6 তারিখে দেখুন। No, 6th is this thing, Saturday.
Saturday,
is the
then
sixth
5th,
and seventh.
5th they call.
No,
I
actually,
want the seventh
Friday,
seventh
this
Sunday.
part hard and assigned matters are taken. So that
Then
is-
4th,
that can be done. No, 4th, 2 p.m. one matter is fixed. So 4th, I can keep it at 3 p.m.
yes.
Very well, Lord, we'll
Or
take
shall
a
I
chance.
keep that on that day? That is other is
The,
7th.
the other matter, Lord, that other side have been informed already.
No, other matter is fixed at 2 p.m. on that.
On 7th.
7th, it is at 2 p.m.
Yes.
Then to
So
Sunday,
shall I
no?
keep it?
It must be 8th.
No, no, 8th, 8th.
8th.
8th, it is kept at 2 p.m.
Lordship.
So I can keep this at on 4th at 3 p.m. 4 তারিখে দুটো সময় আছে বললেন। Either 4th at 3 p.m. or on 8th at 3 p.m. Either.
According to the convenience of my learned friend and my lord.
Any day at 2 p.m., my lord?
8th at 2 p.m. Mr. Mukherjee's other matter is there.
No, sir. 4th at 2 p.m.
4th তিনটের সময় কিছু নেই। আচ্ছা, let this matter appear on 4/12/2025 at 3 p.m.
Lordship.
Grateful to your lordship.
Much obliged.
Lordship, উঠে যাবেন।
কি হয়েছে? হ্যাঁ? পাঠিয়ে দিন, হ্যাঁ দেখি। এটা পাঠিয়ে দিন, ইয়ে করে দিচ্ছি। এটা নিয়ে যেতে
নামগুলো দিয়ে দিন।